Good morning, everybody, and welcome to the District of Columbia Court of Appeals. We have 3 cases on this morning's regular calendar. The first one is George Bell versus United States, number 23 CM 998. Mr. Myers, whenever you're ready.
Thank you, Your Honor. Good morning, Your Honors, and may it please the court, Peter Myers on behalf of Mr. George Bell. I hope to reserve 3 minutes for rebuttal.
Sure.
I'm intending to focus my argument this morning on the first search and seizure issue and rely upon the briefs with respect to the second sufficiency of the evidence issue. There are 2 prongs to my search and seizure argument. First, that the government has not met its burden of showing that Officer Alacron had probable cause to search the bag based upon the factual findings which the trial court made. Second, that Mr. Bell did not freely and voluntarily consent to the search of the bag. With respect to the first issue of probable cause, I want to be clear, pardon me, right off the bat, that we do not contest the factual findings made by the trial court. And it's true that prior to the search of the bag, Mr. Bell said to the officer, "That's my bag, and I have weed inside the bag." If this was any other illegal drug but marijuana, that would have provided probable cause to search the bag. But marijuana is a different situation because under DC law, possession of up to 2 ounces of marijuana is legal, or it's not illegal. And the fact that he admitted having marijuana in the bag does not in and of itself provide probable cause.
So I think perhaps the government's best fact is what you can hear in the body-worn camera, your client, Mr. Bell, saying, which is something about, and the judge is onto this as well. I don't know if she makes a finding about it, but she definitely comments upon it, that he's going to take the blame or, something along those lines. Why isn't that sufficient to basically communicate, I know that I, committed a crime?
And that's the government's interpretation of it. There are 2 problems that we see in relying upon this. First, as Your Honor indicated, the trial court did not make a factual finding in ruling on the denial of the suppression motion on that comment.
Well, isn't it? I mean, I guess it depends on what is a finding, because she does say, doesn't she? She says, oh, and she keeps focusing on, him admitting that it's weed, and I'm not going to lie. She says that many, many, many times. But I think at the very end, am I right about this? At the very end, she actually says, oh, and he says something about.
No, I hope I'm not misquoting the trial court, but
maybe it's the prosecutor who says that.
Neither the prosecutor says it either. What's so striking is that certainly what Your Honor said in making her ruling after hearing the arguments of both sides, the trial judge does say, he said it was weed, and he does say that I'm not going to lie to you. So those are the findings.
I think she says something about take the fall, though. He says he's not going to take the fall. She doesn't use the word blame. So if you search for blame, you don't find it. But
it's my weed. I'm not this, and I am, and I'm not going to lie to you, officer. But she does not. In her ruling, in the transcript, it's an oral ruling on the end at the conclusion of the suppression motion, she does not make this finding. Interpret.
I guess whether or not she makes it, can't we rely upon it as a fact at the suppression hearing, as it's something in body-worn camera that you can hear him saying?
Well, but I think that even though there is language in this court's decision that you can rely upon the totality of the evidence, there's also the decision which we cited in our reply brief, which says that if it results in procedural unfairness, because it's significant that it shouldn't be made, because it's significant that in the government's opposition to the motion to suppress, and in the government's oral argument at the end of the suppression hearing, the government never asks the court to make this finding
This makes
or to
me
interpret
think,
it.
this makes me think that you view this as really dispositive. Is there, is there another?
I don't agree. Good. So my first argument is that it's procedurally unfair because the defense counsel never had the opportunity to respond or to interpret it in a different way. The government's.
Well, they could have done that at an argument, right?
Was not defense counsel wouldn't have responded to an argument that the government counsel never ever made, even either in their written opposition to the motion to suppress or the government's proffer of what it's asking the trial judge to find. So
seems like there might be an incentive to say something about it, given that it's something he says and it's pretty, it's pretty compelling.
Well, but it's subject to, that's the second point. The government is arguing that this language, I don't want anybody else to take the blame, necessarily means that he's acknowledging he has more than the legal authorized 2-ounce. But that's not the only interpretation of that language. I mean, here's an officer who said, listen, unless you admit that somebody is that this is your bag, I'm gonna take it to the police precinct and burn it. Mr. Bell could have said this thing for a number of reasons. He didn't want the police to hassle any of the other men who were there, that he was taking responsibility for the bag. I don't think that the government's interpretation, which defense counsel never had the opportunity to respond to, and the trial judge, why didn't the trial court make a finding on this? Maybe the trial court found it was ambiguous. The government's interpretation that this is acknowledging he must have had more than the authorized 2 ounces is not the only interpretation of this. And because defense counsel never was responding to what the government counsel was arguing, that you should make this factual finding. The prosecutor never said that in the written or oral conclusion to the hearing. It would be, procedurally unfair for this court to assume the government's interpretation of this is correct. Yes, it's certainly on the videotape, but my argument would be that twofold, that number one, there's a number of interpretations of that statement. What did Mr. Bell really mean by it? And the fact that the trial court didn't make that specific factual finding, is an indication that this court should not rely upon it either, because defense counsel never had the chance to engage and respond and explain what that language may have meant. And if you look at what the trial court found is, I have weed in there, and I'm not going to lie to you. And again, if this was any other illegal drug, that would have provided probable cause to search the bag. But it's significant that the DC code, which I cite in my reply brief, section 4892102A says, possession of marijuana without evidence of a quantity in excess of 1 ounce shall not provide reasonable suspicion for a search. So based upon that DC code provision, I think the government cannot claim that before they pulled the Mylar bag out of the Walmart bag, that they had evidence that there was more than 1 ounce in there. If it's
what they are claiming, right?
Well, but I don't think the evidence, that's their burden to show, and I don't think they can show it. The officer says, I shined my flashlight in the Walmart bag. I saw a Mylar bag there, which is consistent with packaging for marijuana, but it's also consistent with packaging for other foods and produce to keep them fresh.
He admits it's marijuana before the search.
Right, but he does, but up to 2 ounces of marijuana is not illegal. That's true. And again, as the statute, the DC code says, which if there's not evidence that there's more than 1 ounce, that doesn't provide reasonable suspicion for a search. And if it can't provide reasonable suspicion, how can it possibly?
Do you want to address whether the search was consensual?
Yes, so that is the government's second argument. The government says, and the trial court found, that whether or not there was probable cause, he voluntarily handed the officer the bag. And we strongly contest that, Judge Glickman, also, that if you look at the totality of the circumstances here, from the very beginning of Mr. Bell's contact with the police officers to the very end, this does not cry out of free and voluntary opening the bag, but responding to the police officer's orders every step of the way. Officer Alacon drives up, his partner calls out to the people, you're standing in a a building site, move away. Mr. Bell and the other gentleman with him move away. He then says to
It's
the,
interesting that he moves away without taking the bag with him. He abandons the bag, as it were.
that point.
The officer then sees there's something of interest here. And the officer doesn't know whose bag it is or anything, but appellant acknowledges, well, it is my bag, and appellant then comes back. The officer basically asks him, what have you got in this bag? He allows the officer to see it. He doesn't object. I wonder if there is a consent situation here.
I mean, we contest that, Your Honor. It's certainly true that when the officer says move away, Mr. Bell and the other people move away, but then Mr. Bell comes back because not only has he left his Walmart bag there, but he's left his cell phone there. You can
Yes,
see, you
that's
can
right.
see in the videotape, Your Honor, that he picks up the bag and his cell phone and begins to walk away. And at that point, the officer Alacron says to him, hold on, show me what's in that bag. And then Mr. Bell hands it to him. And then he says a second time, I want to see what's in that bag. I think if you look at the totality of the circumstances, which this court has pointed to in other cases, you're in an alley. You can see in the video that Officer Alacron's partner is out of the car standing on one end of the alley. You can see a third police officer standing on the side of the alley. You can see Officer Alacron's partner and Officer Alacron repeatedly telling Mr. Bell what to do. So I think that even though the trial court found that this was a voluntary.
Well, that's where I was going to go. I was going to ask you to address the court's factual finding that it was
Right.
Consensual.
That's right. And again, we would urge the court, by looking at the totality of circumstances, that this officer is consistently ordering, Mr. Bell to take a number of actions, move away from from where you're sitting. Then when he then goes back again, perhaps initially abandoned, he goes back and picks up his bag after saying it's mine and I have weed in there, picks up his bag and his cell phone. I think that whatever abandonment argument, I think, that is now the events move beyond that, because he's going back and retrieve it after the officer first said, move away from that area. He goes back and retrieves it. So I don't think we're on an abandonment basis. And then I think the officer twice says to him, show me what's in this bag. So I think there are cases which the government cites in its brief, Henderson and Brown, in which police officers do politely ask in a conversational tone, are you willing to show me if you have any drugs on you? Are you willing to open the hood of the car? And those two defendants voluntarily complied. I think this case is totally different. I think if you see the video and the way the government quotes what's said by Officer Alacron, he's demanding, show me what's in your bag. I don't think that the trial court was correct. It's clearly wrong in terms of making the conclusion that this was a voluntary.
And if I may, before you sit down, there was a stipulation that the contents of the bag did constitute marijuana, but there was no, as I understand it, there was no actual evidence, no testimony, no other evidence presented by the government as to the quantity of the marijuana in the bag. Do I have that correct?
That is accurate.
Now, the government suggests that the failure of the quantity is an element of the offense. There has to be, at best for the government, more than an ounce, if I understand correctly. Well, if he intends to distribute, I think it becomes an ounce, but whether it's 1 ounce.
That's true.
Okay, so 1 ounce or 2 ounces. And there's no evidence about how much at the trial presented on that subject. The officer doesn't testify that it was, more than 2 ounces or what have you. The government's answer to that is, well, this was an invited error. This absence, and the judge makes no finding either. this absence was an invited error. Do you want to comment on whether the invited error argument works for the government?
I think it is accurate to say that when this issue is raised, defense counsel does say, Your Honor doesn't have to get into what the amount of the marijuana in the bag was. So that is true. And I point out in my reply brief, it's perhaps inconsistent for the government to point out that that on our second sufficiency of the evidence issue, that defense counsel should not.
See, I'll tell you, and this will help the government address my concern here too. Yeah, there's fault on the part of the defense counsel, but there's also fault on the part of the government. The government didn't put on the evidence. And when defense counsel says that, the government is happy to, well, I shouldn't say that, but the government doesn't dispute the point.
Yes.
And be all that as it may, this is after the government has rested. And there either is sufficient evidence. So we have a situation where where there may be insufficient evidence. The government may argue, well, you could just look at the bag and see, but I'm not sure that works. And so there was insufficient evidence, and the court has never made a finding with regard to the sufficiency, with regard to this element of the offense. That's sort of been nagging at me a little bit.
Yes, and I think Your Honor has accurately expressed the concern on that sufficiency of the evidence issue. And again, unless the court has any further questions, I would be happy to and stop now for the time being and reserve a few minutes for rebuttal.
Okay, we will give you the 3 minutes you
Thank you.
requested.
Thank you.
We'll hear from the government now.
Your Honors. May it please the court, Matthew Brock for the United States. Your Honors, officers of the Metropolitan Police Department had probable cause to search Mr. Bell's bag at the time that they asked him to open it and if they could show what was inside of the bag. Your Honor, at that time, Officer Alarcon had seen that there was what he called a 2-foot by 2-foot blue Walmart bag that had been left behind. And he saw inside of it a Mylar bag that was consistent with packaging for marijuana. And he stated that he testified that this bag took up approximately half of the 2-foot by 2-foot blue Walmart bag. In addition to that.
Oh, but didn't he, I thought he backed off that and said that, that he couldn't perceive that until later.
My understanding of reading the record was that he understood it took up, from what he could see, approximately half, but obviously he wasn't able to determine the full size of the bag and the amount that was contained within the bag, obviously, definitively, until it had been fully pulled out and he could observe within it.
I thought he had been very clear that he could see the Mylar bag, that in his experience meant, it could be packaging for marijuana, and that he just really couldn't. It was almost like he didn't want, it's almost like amazingly candid. I couldn't tell the size of it. And then he does make the point that you say, which makes it sound inconsistent with everything else he said about how he couldn't tell the size of it. But then he sort of makes clear that, well, he doesn't, it's all very kind of cryptic, but it's how I read it was, well, later on, I knew it took up like half of the bag.
Specifically, what I have on my abbreviated notes, Your Honor, is I cited myself to page 67 of the transcript just to reference for Your Honors. I don't have the specific language in front of me to address that, but my understanding was that.
Right, and I'll read to you what
thank you.
It says there. How much of the Mylar did the Mylar bag fill up the blue bag? It was about half of it. Were you able to tell the blue bag was about half full? I wouldn't be able to tell if it was half full. It was definitely an item in there. So he takes it back.
Understood, Your Honor. Your Honor, but in addition to that, I think this is very clear from the body worn camera footage that we have. He's at least able to see the top of the Mylar packaging. And
he can see, he knows it's weed, and he can see a bag that's consistent with transporting marijuana. He has no information about the weight, and the weight is everything, right? Because if it's under a certain weight, it's not illegal. And it seems like he has to have some sense of the weight to be able to say he has probable cause. And I understand him to admit that he really doesn't have a sense of the weight until he opens the Mylar bag. It's on page 31 let's see, at that point, what if anything, had you determined, this is on page 31, about what the defendant took out of the bag, it was in excess of the amount of marijuana that you can have in a public space? That's when he figures it out, is after he takes the bag out. But before that, and that's what we're concerned with, because we will need to know whether he had the probable cause to search the bag. Really, right, it's the probable cause to arrest Mr. Bell and search him instant to arrest for illegally possessing the marijuana, right? Like, you don't just get probable cause randomly to search things. So,
Yes, Your Honor.
yes,
That's
okay,
correct.
just making sure that we're all on the same page as to what we're talking about. But it doesn't seem like he has any sense of what the weight is until he actually until the Mylar bag is actually out and open for him to view it.
Your Honor, my reading of that is that is the point where he is definitively able to say in his training and experience, seeing the marijuana inside the
Does he
packaging.
say anything about weight before that time?
Your Honor, he does. I think the issue is that it's not that he's able to definitively say this is over 2 ounces at this point, but it's
Does he say anything about acknowledging that that Mr. Bell is allowed to possess under 2 ounces of marijuana before this point?
I don't
Right?
think
Like,
he
is there any acknowledgement by the officer that he recognizes that there's a legal amount of marijuana that someone can possess?
Well, Your Honor, I think on page exactly the part Your Honor quotes is the part where he, in his statement of "I knew it was in excess of the legal limit," establishes that all his prior testimony.
Right, but my point is, like, there's no point before that where he seems to be assessing, oh, do I even have probable cause? Like, to your point of, well, that's when he definitively knows. Okay, fine. But there's no evidence in the record that at some earlier point that he has a lesser suspicion or probable cause to think that the weight is sufficient. It's just, he knows nothing and then he actually knows.
Your Honor, I think the evidence for that is the fact that he begins this inquiry into who is the owner of the bag. And then once Mr. Bell comes and takes ownership, begins
That he has a hunch, he has concerns, he wants to investigate. But I'm not sure that it gets him to be able to search the bag.
Well, Your Honor, again, all that is necessary for probable cause is a fair probability of a crime, which is less than the preponderance of the evidence. And so I agree.
I actually raised the question of when the seizure takes place. When the officer picks up the bag, it's been abandoned. And I'm not sure that constitutes a seizure. When he looks into it and sees the Mylar covered contents, first of all, that may have been that may actually not even have been a search at all, because it may have just been, visible to the open air to anybody walking by. But even if it was a search, this was at that point was an abandoned bag, and he's trying to figure out, what should I do? Should I bring this back to the station to have it destroyed, or any of you guys know anything about this, or what have you? But even if we assume that seeing the things he saw mounted the hurdle of probable cause, or did not mount the hurdle of probable cause, where do you come out on the consent question?
You're right. I guess to answer Your Honor's first question of when was Mr. Bell stopped, I think it's pretty undisputed from the record that he was stopped at the point that Officer Allerton, I think, testifies. He says that he ordered or directed him to stop walking away. And that was the point at which he was stopped. The government would submit that we had probable cause, and at bare minimum, we'd have reasonable suspicion to execute a Terry stop at that point.
But wait a second. I mean, a Terry stop gives you a protective frisk. It doesn't get you to search bags for marijuana. So I'm not sure, I'm not following.
Well, you're
right?
right.
I thought we were, again, just to go back to my earlier point, right? The way that you get to search, the police get to search the bag is to say, it's a search incident to arrest. And under our case law, you can do the search prior to the actual arrest, right? If you have probable cause to make the arrest, you can have probable cause that probable cause allows you to search the bag that the person is possessing incident to the arrest. This isn't about Terry stops, and I didn't understand the government to be arguing that this was a search pursuant to a Terry stop, because that argument would fail, right?
Your Honor, we would submit
Are
that
you trying to make a Terry stop argument?
it's not the Terry frisk, it's the stop, given the fact that the officers, again, while we assert that there was probable cause, incumbent in that is that there was reasonable articulable suspicion that this was in excess of
Okay,
2
fine.
ounces. So
They stopped him to make an inquiry, but I don't understand how that helps the government here, right? So they stop and then they command him to do certain things, right? Hey, let me see, open them, is what the officer says on the body worn camera. And then the defendant complies and gives him the bag. And then the officer says, this is your bag, right? Yes, sir. Let me see what's in there. Come on.
Your
Right.
Honor,
These are directives. And it seems to me that the officer even testifies that they're directives. He talks about how the defendant complied with his commands on page 60, I think.
yes, Your Honor, I would note, I believe he specifically, in response to defense counsel's question, acknowledges that it was an order of telling him to, I think it was hold up or hang on there for a second as Mr. Bell
And
was
then
walking
you
away.
ordered him to open the bag, correct? I asked him to show me what was in the bag, yes. You said, let me see what's in there, man, come on. Yes, sir. And Mr. Bell complied, correct? Yes, sir.
Yes, Your Honor, and I think that the officer characterizing it, changing and saying, I didn't order him, I asked him to do it. And I think that
But he agreed that Mr. Bell complied.
yeah, I think Mr. Bell essentially overcomplied by handing it to officer, and I think it's Officer Allerton's actions there is very telling. Officer
That's
Allerton,
when he pulled out the bag at your request? Yes, sir.
Your Honor, if you look at the body cam,
I did look at the body cam, but I'm saying they asked the officer, he pulled out the bag at your request. Yes, sir.
that
He
was
did exactly what the officer told him to do. And
Yes, right.
so for the government to now argue, well, actually, he did something that the police officer didn't tell him to do. He voluntarily did this thing. That actually is contradicted by the officer's testimony.
Your Honor, I would note that there's two requests, two questions and requests that are made by the officer.
I'm sorry, didn't the government in your brief argue that he pulled out the Mylar bag voluntarily and that's not what the officer asked him to do? And here he is asked, that's when he pulled out the bag at your request? Yes. So the officer is saying, when I said, this is your bag, right? Let me see what's in there. Come on. That was a directive to pull out the bag, and he did what the officer told him to do.
Right.
Didn't go above and beyond, according to the officer's own testimony.
Your Honor, I believe the officer's specific question that was asked was, let me see what's in the bag.
I understand what he said. What he understood himself to be telling the defendant to do was to take the Mylar bag out of the target bag. And he's asked about that at the hearing, and he agrees that the defendant did what he asked him to do.
Yes, Your Honor.
Got it.
I guess my reaction is that the consent issue, your best argument, I think, for saying consent is that Mr. Bell voluntarily returned when the officer just held up the bag and said, what's this? What do I got here? Am I going to destroy this or what? And he voluntarily returned and said, look, it's mine. I'll take the blame or heat or, whatever. That bespeaks a certain degree of willingness to consent and get this thing over with and do what the police want. I'm not saying that I take a position that it's enough to show consent, but I do think that there's a close question here at best about whether this was consensual or not. And if it was consensual, then, we go from there. You know that I'm still bothered by the fact that there's no evidence at trial as to the amount of marijuana that was in there. And the government acquiesced in the absence of such evidence. So tell me about, what's your response to that? Was that seeming failure of evidence on an essential element?
Absolutely, Your Honor. And I think part of it is the case coming to this court in an odd and uncommon posture. coming specifically after a stipulated trial, rather than a normal trial where the government would very likely have placed
To define terms, I'm sorry to interrupt, but is it a stipulated trial? You know, in the transcript, the trial defense counsel says something like, it's not really a stipulated trial. We're just stipulating to some facts and you just, you know, you can take what came out at the suppression hearing and our stipulation to it was marijuana and there's an intent to distribute and go from there. Or is that what a stipulated trial is?
Your Honor, that is, I do understand the defense counsel, I think quibbles or contests some of sort of the terminology that's being used, but it seems very clear to the trial court and to myself as well, that this is what you're stipulating that the elements are met and that the evidence is in there and the government can establish it so that you can then move on with you understanding that the suppression issue is likely dispositive in the case at hand. And so I think that context is in which Your Honor's question would need to be addressed. And I think part of it is understanding that they're taken all together. There is evidence, well, not direct evidence of a testimony as to I have weighed it on a scale and this is what it is. There is testimony as to the amount of marijuana with regards to its appearance within the bag. The physical bag was placed into evidence. The trial court was able to observe the amount of marijuana. Indeed, the trial court was able to observe as it kind of exploded over the courtroom.
I'm sorry, I didn't quite catch what you just said. Say that again, please.
Apologies. The physical bag, the Mylar bag and the marijuana within was introduced into evidence. So the trial court was able to see the bag and the marijuana within, and indeed it saw it as the marijuana sort of exploded over the courtroom as the prosecutor perhaps unwisely attempted to open the bag at trial.
Nonetheless, I mean, that was an amusing interlude that we don't usually see. With the trial judge worried about everyone getting a contact high from the marijuana flowers. But even though they went everywhere, I mean, I have no idea how much a marijuana flower weighs, right? It could be like a dandelion, you know, when they turn white. And so 100 of those could weigh nothing. I mean, I honestly, I have no idea how much a bag of those, that's scattered all over the courtroom. And there's no evidence in the record. And even though the court saw the marijuana flowers, she still doesn't have any sense of the weight. I don't understand what seeing it does for the government.
Your Honor, I think that, and I'm going to take sort of an extreme hypothetical, but if we were to drag an 18-wheeler and stacked full of marijuana, it would, the government's position was that it'd be reasonable for a fact finder to make a factual determination that I don't have an exact, we haven't put this on a scale, but I can tell you that this is more than 2 ounces. And obviously there may be a line where it becomes harder and harder to determine. And our position is that the court in its ability to observe the amount of marijuana in the bag, we would also note that the physical bag itself has written on it net weight 1 pound. And we would note that the court is able to observe all of this information.
Is that in the record?
Well, Your Honor, the physical bag itself was placed into
Does
evidence.
anybody talk about the bag saying it has net weight 1 pound on it anywhere?
No, Your Honor, it's not specifically talked about, but it is on the physical bag.
Okay. So we're supposed to look at the photograph of the bag and see that?
You know, I don't know if the fact that the bag has a label.
We denied that, I'm sorry, like
Well,
the photographs aren't even in evidence.
My apologies.
So I'm not sure how we would know that the bag says.
I will retract that. My
Okay.
apologies. But Your Honor, again, I think it is the fact that the fact finder is not required to leave their common sense at the door and can make a factual determination.
Right,
And-
we're not supposed to leave our common sense at the door, but we do rely on the government to present evidence. I'm worried I cut off Judge Glickman, so I just want to make sure that he got to ask his question.
Well, we passed it. I was just going to say that the fact that the bag has a label on it that says 1 pound, I don't think gets you where you want to go. We have a case where the police didn't present evidence of the alcohol content. This is from memory, so forgive me if I have this. And they relied on the fact that the can said something like I don't know what it said, half a fluid ounce, I don't know what, of alcohol, whatever it said, and the court said that you couldn't rely on that to satisfy the government's burden of proof. And, I mean, here, it's not just that what's sort of bothering me is that it's not just that defense counsel's, that defense counsel, what's the right word? Acquiesced, in, or actually, it's more than acquiesced, encouraged the judge to think that the amount, was not relevant to the distribution count, and that was error. But that there was no evidence that even if he hadn't encouraged the judge, and this was after the trial was over with and closed. So this is what's bothered me the most about this case.
Absolutely. And I think that Your Honor, that's a very fair and accurate point. And I think that, Your Honor, we would note
I
that.
don't see that that point helps you, right? If the government has rested, then whatever the defense says at that point, like, it's not like, I mean, maybe the government could have moved to reopen had the defense counsel said, you know, look, we stipulate that he had, you know, that we stipulate to the evidence that was presented at the hearing.
in-
But
That's a-
but
if
the
you-
evidence at the hearing is not legally
that's true.
sufficient.
But it's not as if there's a representation that the government had the evidence at hand as to the weight of the marijuana and could have promptly. I mean, you know, there's a limit to how much, if I were the trial judge, I might let you reopen, but not for a day and a half, you know.
I believe that there was an expert ready if this case were to go to trial, but I don't believe it was within the bounds of the actual record, on the transcript itself. But Your Honor, I would note that there is, because attorneys in general can make mistakes and can sometimes lead their clients astray. There is an ineffective assistance of counsel avenue by which a client could seek redress if their attorney were to lead the court astray or to essentially concede elements of the offense that a reasonable counsel doing their.
I'm not sure you want to pursue this argument. Are you agreeing that there was ineffective assistance of counsel?
Your Honor,
We could save a lot of trouble if that's your position.
I'm not sure that I have not spent enough time researching it in briefing, so I don't think I can give the government's position, but I think that in factual situations, perhaps similar, that there at least may be an avenue for inquiry in that regard, where a defense attorney were to concede certain elements like that. Whether that is appropriate in this case, I think would be fit for another hearing in another matter with additional briefing.
I thought your argument was, or one of your arguments was sort of along the lines of, yeah, the government has the burden of proof, but it seems odd to say that for the defense to say, we're technically pleading guilty to this. You know, now that what we cared about was the suppression hearing and we lost. And so we just want to preserve our right to appeal that. And we're essentially pleading guilty to the rest, which signals to the government, you don't have to put your witnesses on. You don't have to worry about tricky arguments about sufficiency of the evidence. You know, 1 ounce, 2 ounces, 10 ounces, whatever. But that doesn't seem to be where your focus is today.
Your Honor, I would also agree with that. As we said in our brief, what I say now is simply to add in addition to that. I think, and in part, I think defense counsel's representation is that we don't even necessarily need to get to weight because in their view, it's the actual.
Wait, where did that representation occur?
Apologies, Your Honor.
You're saying a defense counsel essentially made a representation that you don't need to get to weight. When did that happen? I'm just confused, right? So they have
It
the
was.
trial.
I believe it's on page 97, where I believe the trial court specifically makes the inquiry. Have you all reached a stipulation as to the amount of marijuana? I paraphrase here. And defense counsel stated, quote, I think it's just the intent to distribute is what's needed for the finding.
The government agrees.
And the government agrees and at least does not object.
I mean, both lawyers are not, they're making a mistake. They're not thinking about the the law, right?
I think there is at least a misunderstanding or miscommunication at best in this situation where the government's made, it seems clear from the record that the parties are trying to stipulate and agree to and essentially plead guilty to move on to a potential appeal on the suppression issue. Now, obviously, I think we can all agree that the specific words being said don't reach the element because distribution alone is for any other drug perhaps, but for marijuana, given the council's new law or 2015 law does require an amount of weight or age or for remuneration as well. But we would submit that defense counsel's intent seems clear and at least the trial court understands.
I mean, it's just that later on, he says, you know, the court says, what are we doing here? It's on page 101. And the trial counsel says, I mean, technically it's not a stipulated trial. There's just facts ahead of you and you're just deciding the case. And the court's like, well, when I was back in the day, when I was a prosecutor, we called this a stipulated trial. And the trial counsel says, yeah, that's what it is. And then the court says, so at this point, I find him guilty, right? Like it's not a plea. It's the court is saying, based on the evidence that I've heard, I find him guilty. Why can't we just say, okay, the court looked at the evidence, found him guilty, and actually, in fact, as a matter of law, that's wrong. They missed an element. They forgot about weight.
And I think that it is still within the court in that role acting as the finder of fact at that point to assess and make its own factual determinations. It does not give this court a stated findings of fact for this court to rely upon. But the trial court does clearly think about the evidence and make a determination as to believing that the elements have been met. And if your honors think that it necessitates some level of change and not an affirmance in this matter, the government would submit that remand to the court for factual findings.
That would be permissible if we think there was sufficient evidence to permit the trial judge to make the finding you would like the trial judge to make. But at least speaking for myself, I think that's an issue.
And I understand that the court in briefing that it is at issue, and again, the government would assert that there is sufficient evidence for a reasonable fact finder to make a finding of guilt beyond a reasonable doubt, and for that reason, we would think that if the court were to turn around, remand for factual findings would be appropriate. Unless the court has any further questions, we would simply ask the court to affirm the ruling of the trial court. Thank you.
Thank you, Mr. Brock. Mr. Myers, we'll give you 3 minutes for rebuttal.
And I don't think I'll need that much, but I would like to make 2 points. I think, as I both think Judge Beckwith and perhaps Judge Eastley was saying, it's unfortunate that they were confused, in terms of the trial and what was necessary to be found on 2 grounds. Not only, even though the defense stipulated that there was an intent to distribute, as we've mentioned earlier, under DC law, that's not an offense. You can distribute without remuneration up to 1 ounce.
Why isn't it a problem that the defense was basically saying, government, don't worry. All we cared about was the motion. We lost that. Now we're going to stipulate. You don't need to bring your witnesses on. I mean, you can look at this both ways, but what's your response to that?
Well, again, I think as perhaps the questions from the court previously have suggested, I think everybody was under a misinterpretation of what that law actually is, that you did have to establish more than 2 ounces, and that with respect to distribution, it had to be all defense counsel stipulated to is that we did have an intent to distribute, but not for remuneration. So that wouldn't necessarily be.
So it's a situation where your client meant to stipulate to everything that would constitute all of the elements that would, constitute guilt of this offense, but by accident didn't because his lawyer didn't realize.
I wouldn't say it like that. Both sides agreed to a stipulation, and defense counsel is arguing that that's not sufficient to convict in this case. And the other point I wanted to make is that I do remember the open container of alcohol case that Judge Glickman referred to. I don't remember the name of the case, but this court held that just the packaging, the fact that it was in a liquor bottle, wasn't sufficient to convict the defendant of possession of an open
Oh, I
container.
thought it was a can. All right, liquor bottle.
I think it was a bottle.
tequila.
It was some sort of, but you know, because the police didn't smell it, they didn't taste it. You know, they didn't have any additional evidence beyond the packaging. And therefore this court said the mere fact that it was in an alcohol bottle and it was liquid wasn't sufficient, you know, to convict the defendant of possession of an open container of alcohol. So I remember that case as does Judge Glickman. And if the court has no further questions.
Thank you very much. Thanks to both of you for your briefing and your arguments in this case, and it will be submitted. Second case on this morning's calendar is number 24 CT 1078, Leon Ernest Williams versus District of Columbia.
It please the court, Jason Clark on behalf of Mr. Leon Williams. I'd like to reserve 3 minutes for rebuttal if I can. Mr. Williams' conduct did not fall within the ambit of the statutes and the regulations that the district threw upon him. The evidence was therefore insufficient. Even if his conduct did fall within the ambit of the statute, then the evidence obtained was unlawfully or the evidence was unlawfully obtained. And finally, Mr. Williams' conduct, if it did fall within the statute, was in violation of the Second Amendment. And so I do have a number of issues. I think if I'm going chronologically or starting, it makes sense to first address the Fourth Amendment issue. In this case, we have argued both that the government failed in its burden of proving that there was reasonable articulable suspicion for the initial stop of Mr. Williams. The first issue that was highlighted or relied upon by the government and the court was the issue of the license plate. That, however, seemed to be primarily an misunderstanding by the court, which the court had ruled the license plate had to be displayed, or seemed to suggest that the court understood the license plate needed to be on the bumper.
So I take your point. 18 DCMR 422.1 doesn't say anything about displaying a license plate on the bumper, right? It just says that you know, when a vehicle is being operated or left standing upon a public highway, it shall display, you know, 2 tags on the front and on the rear. And it doesn't really say what the front and the rear is. But the government also cites in its brief to this court 422.4, which requires tags, quote, at all times to be securely fastened in horizontal position to the vehicle and at a height of not less than 12 inches from the ground, in a place and position to be clearly visible. And I'm wondering why that either singularly or in conjunction with 422 didn't give the officer at least reasonable articulable suspicion to think that this regulation was being violated. You know, he testifies that, you know, they couldn't see the tag. It wasn't affixed to where it was supposed to be. And then he says, and then actually your client testifies that the officer only noticed the tag after the stop when he was walking around the vehicle, because your client had it in the dash, I guess, in the window.
And that's my understanding as well.
Why isn't that a basis for the stop?
I think that there are a couple of issues. One, this was on private property. So it was at the Crown gas station. So he had stopped the vehicle. He was no
But
longer.
they saw him driving on the road. They saw him pull into. I think the testimony is we see him pull into the gas station and we didn't see a front tag. Right.
think
So he
that's a fair
doesn't
reading
see
of the
it.
record.
And like, why doesn't that give him suspicion at least that this tag is not clearly visible?
I think that might give the court a ample record to make that determination, but what the court did was it ruled that it was not on the bumper. And I think that the court may have misunderstood the regulation that it was applying, and that may have been an abuse of discretion. There was one other
We were
issue.
doing de novo. I thought we were doing Fourth Amendment reasonable articulable suspicion. Did the officer have reasonable articulable suspicion or not? I mean, is your point that nobody was talking about 422.4 in the trial court?
I think my point is that the court simply misunderstood the regulation that the
Right, but
government
at
was
this point, our review is de
alleging.
novo. So it doesn't matter, like, we're not deferring to how the trial court ruled on this. We get to look to see whether or not there was reasonable articulable suspicion. If you were gonna say no one called, the government didn't preserve this argument that there was reasonable articulable suspicion under this other regulation, that might be an argument, but I'm not hearing you argue that.
No. And so I think one other issue that the court had identified was the tint. And I don't think the record actually made out a tint violation.
Well, that maybe, and that's an interesting issue, whether or not whether a tint violation was actually proved, and that might be important for the inevitable discovery argument. But again, if you're just talking about a basis for the stop and whether there's reasonable articulable suspicion, if you see a car and say, gee, the windows look heavily tinted, right? Don't you think that that gives a basis to stop the car to then do whatever it is they do to measure the tint to make sure that it's legal? I mean, that's.
I think the one key difference that I would say, and I believe you're correct, if the implication is that, hey, that is heavily tinted, so heavily tinted that I believe it's below the legal limit, and the officer just simply never specified. So the officer's only testimony that was heavily tinted, and it was left open in the record what the officer meant by heavy. And obviously the court understood that to mean illegally heavy, but I don't believe that the record makes that clear. And that would be my point on that.
Let's assume that we think that there was a basis for the stop. Do you want to talk about whether or not there was a basis for the search?
So even assuming that the initial stop was permissible, the police lacked any legal sufficient justification for the search of the actual vehicle where the gun was recovered from the center console. I know that the trial court sort of relied upon the search incident to arrest. That seems to be an issue that the district
Government doesn't seem to be defending that.
Correct.
That seems to be
I
out of the
think-
case. They seem to acknowledge the trial court was wrong on that.
And that sort of leaves two primary issues, which is whether or not the canine search itself established probable cause and whether or not there was an inevitable discovery issue based upon an inventory search. I think first, the inventory search is a pretty easy issue because as the officer testified, there was no inventory search. The government did nothing to initiate an inventory search, and the inevitable.
No, but it's inevitable discovery. So obviously, like there wasn't an inventory search, but their argument is, had there been, we would have. But I thought your argument there was there's no actual window tint violation, so there's no inevitable discovery argument, right?
No,
Like
I would say that is not my argument.
that's
My
not
argument
your argument.
is
That's
that-
unfortunate that that's not your argument, because that seems like a pretty good argument to say that it wouldn't have been inevitably discovered because in fact, there was
think-
no proof that the windows were actually tinted.
Is the court referring to just the visibility of the gun itself because of the tint of the window? Okay.
I'm just talking about the window tint violation and
think
whether or
that-
not.
No,
the-
I would say that we
The
certainly
government
raised
seems
the-
to argue that they had to tow the car. This is their argument now. It's not their argument what they made in the trial court, but they argue now they had to tow the car because of the window tint violation, right? And once they decided that they had to tow the car because of the window tint violation, then they had to do an inventory search. And so it was inevitable discovery. But as you argue in your brief, they never proved a window tint violation. So just as the windows are heavily tinted doesn't mean that there was an actual window tint violation that would require towing of the car that would then justify an inventory search. I thought that's what you were arguing.
Yes,
in your brief.
and I'm
Okay.
sorry, and I misunderstood the court. So yes, that is part of our argument. And the additional part of our argument with the inventory and inevitability of it was that this court's law makes clear that in order for it to be inevitable discovery, the process has to have already started. It has to have gone in parallel with the actual lawful process. And that did not happen here. So they had not started any part of the inventory search before they actually went ahead and just did a general
What is the
search
government's
before they
argument
got-
that the contrary to that they did start it? Is it that they sought they were seeking doing the warrant search or something? What is their argument? That they
I don't think they
had
do. I
started
think
it?
the officer flatly says, no, we didn't do an inventory search. We just called for.
I mean,
Yeah.
on appeal, the government's argument that the process had started.
I don't think that there's anything in the record for the government to point to say that the process actually starts. There's the regulations, the MPD's general regulations, which lay out the process. And it talks about how they have to call OUC, they have to call for the tow truck. They would then do the search before the tow truck takes it. And there's a number of things that have to be done. And so none of that evidence is in the record. The officer never says that he called for a tow truck. And in fact, I do not believe that, that this car was towed away. It's my understanding that the
Well, they
wife
never
arrived
called
and
for the tow
took
truck
it.
because they never established that there was a tint violation. So
Correct. And I
say
think
we
that.
agree with you on inevitable discovery doesn't get the government where they want to go. Let's talk about whether or not there was probable cause under the automobile exception.
So ultimately, nothing in the record supports the conclusion that the dog here was what the district now claims it to be, or what the trial judge clearly presumed it to be. The record or the district requests this court treat sort of the absence of that evidence in the record is purely speculation, because what we have is only the testimony from Officer Chase that there was a dog on scene and essentially the dog signified something, he believes, and then they proceeded with the search. But there is nothing from Officer Chase to say that this was actually a certified canine officer, that this was a trained dog, as to what this dog was trained to actually do, or if the dog
The
actually
government says that
didn't
this
work.
argument isn't preserved. And what's your response to that?
The issue of whether or not there was probable cause is absolutely preserved. There was a pretrial motion, there was the full hearing on it, and the trial court made findings which are not supported by the facts in the record, but made findings upon the issue of the canine search. And all that the appellant needed to do was really to raise the issue of the unlawful warrantless search.
Officer
and within
testifies, when the officer just says, well, I saw the canine and the handler and I saw what looked like the canine alerting to the handler, the defense didn't have any obligation to cross on that to say, what do you know about canines? What do you know about this dog? Like, you don't know anything. The defense counsel could just stay quiet and just not say anything.
They could, it was not their burden.
And in the absence of any, challenge to the reliability, what is your best case that the government has this affirmative burden to
I think
put on more evidence than they did in this case?
as I cited in my brief, I think my best case is in Ray KH, which talks about vague and unenlightening testimony. And I think that's what we have here from Officer Chase, was vague and unenlightening testimony. And I think that the point the court makes in the in Re KH is that while, certain amounts of hearsay is admissible, there still has to be a reliable basis for that hearsay. And what we have here is there was no reliable basis for really what was Officer Chase's assumptions about what happened with the canine officer. Had Officer Chase said, hey, I talked to the canine officer, he said, yeah, this is my dog. It did in fact alert on the vehicle. And my dog is trained to alert on these things. So based upon that, I think there's probably this in the vehicle. But that
I think that
simply
would be
did not
enough
happen.
under, didn't you cite Harris to us? Florida versus Harris? Is it Florida versus Harris?
Yeah.
I may have.
You think just having, even if the handler had showed up and testified, my dog alerted to this vehicle, that would be enough under Florida versus Harris?
I don't think that, okay, I don't think that that alone would have been enough, but it may have made Officer, it would have increased the reliability as far as what the trial court was relying upon. So I do think that there are deficiencies. I think that there.
Mr. Clark, help me out here. Did at the hearing, did the defense counsel actually argue that there was no probable cause, that the dog's qualifications had not been established, and or anything of the sort?
No, and in fact, there really was no argument, as the trial court had said at the motions hearing. What he wanted was sort of a proposed findings of fact. And he asked both parties to submit a proposed finding of facts, and he really did not permit any argument from either side.
Did he in effect concede that there was probable cause once the dog had alerted?
I do not believe so.
The government took that position in its proposed findings? Is that right?
I don't recall them taking that
And I'm wondering
position.
how this, because I think that's sort of a key issue here. Was there a determination that we would defer to that there was probable cause to search the car? There's a preliminary question as to why the police were entitled to detain the car before probable cause was established, but I'll ask the government about that.
And then I think that moving on to just the sufficiency of the evidence and what are the statutory construction issues here. First, I think that it is clear that the failure to holster regulation requires that the holster requirement only applies when it is actually on the person. The second part of the regulation.
I'm gonna, it's hard because I feel like you need to like project the language up onto a screen or something.
Absolutely.
I'm gonna try and read it neutrally. The regulation says a licensee shall carry any pistol in a holster on their person in a firmly secure manner that is reasonably designed to prevent loss, theft, or accidental discharge. And so how do you read that regulation?
I read it as in a holster on their person. So when it is on their person, it must be in a holster. If it is not on their person, then I would look at 2344.1, which says that essentially when it's in a vehicle, it must be out of view of the public, is sort of how I read those two regulations in harmony.
And there's no other, I mean, other than the text, is there anything else to point us to how to read this regulation? And you're telling us to look at 2344.1.
I think with those regulations, no, I mean, there's really not much else.
So the government says, okay, even if we read this regulation your way, that, so I would read it as a licensee shall carry any pistol in a holster on their person in a firmly secure manner, right? the government says that your client admitted that when he moved the gun from the trunk, from the lockbox in the trunk to the center console of the car, that it was not holstered. What's your response to
He
that?
did not say that. All that was said was that he had moved the firearm and left it in the center console. He never testified as to how he moved the firearm, what was happened when he removed it from the lockbox, and that was one of the other
The
issues.
government didn't ask him.
Correct. The only testimony that he has on that part is that he does say, you know, he removed it from the lockbox, and that when he went in to the convenience store, that he had left it in the center console. There was and this also comes up in the issue of the unlawful transportation, but his testimony was that he had left the firearm in the center console, and he said that it was loaded at that point. But there was no testimony about how it was actually being stored in the lockbox in the back, whether or not upon removing it from the lockbox, he loaded it. So how it came to be loaded in the center console, none of that is actually in the record. The record is completely devoid of any of those facts. What we know is that he got the firearm.
Testifies that he took it out of the lockbox and moved it into the center console and doesn't say anything about loading it. Can't we infer that he moved it to the console in the same state that it was in when it was in the lockbox?
No, I don't think that would be a fair inference on this record. There's really so little.
It seems to be very odd behavior to think that he took an unloaded gun out of the lockbox, took ammunition from the other box that ammunition was supposed to be in, loaded the gun, and then left it in the console while he went into the store. That seems a little far-fetched, does it not?
I think that the
Certainly didn't
sort
say
of the
anything.
reasoning and the explanation that he gave during the sentencing hearing was that he had been previously robbed at that gas station before, and so there was this issue of wanting to have the firearm.
Well, he says
in
that
hand.
at trial too. We wouldn't consider what he said at sentencing.
If-
So, but he says that he had been robbed there before at the trial.
And I do think that it's reasonable that if he's traveling with the firearm and if he has sort of the accoutrements necessary to, you know, lawfully have it stored in the lockbox in the vehicle, that there's no reason that we would presume that it is not being lawfully transported and stored in that manner. And when we have the absence of the record testimony, it was the government's burden to ask some of those specific questions to bring that forward. And I think that when you have a licensed firearm, somebody with a licensed concealed carry permit who seems to be at least, you know, trying to comply with the laws, that it's not fair to presume from the absence in the record that they were doing something unlawfully at a point when nobody can testify about what that was, or the government presented no evidence on that. And it simply wasn't his burden at the hearing to do that.
So do we want to talk, are we talking about the unlawful transportation? That was your unlawful transportation argument?
Yes, there's the unlawful transportation, which I think that the other issue with the unlawful transportation is, so while we don't have any evidence in the record that it was actually, you know, loaded while it was being moved about, as to what was happening prior to it just being in the center console. Additionally, I think that any fair reading of the unlawful transportation statute requires some degree of aspiration, some degree of movement, that it's not simply
But they argued this is
momentary-
attempt, right? So like, you know, you have your response to, okay, well, you don't have proof when I was actually in motion, but they're saying this is attempt and your client is getting gas and clearly is about to drive off into the sunset with this loaded gun in the console.
And again, this is sort of where his prior interaction or his prior decision to remove it from the lockbox, I think that it's not fair to infer it's not going to go back to the lockbox upon leaving the gas station.
You're saying they
If-
don't have, for attempts, they need a proof of an overt act and intent, and they don't have, maybe they have an overt act in pumping the gas, but they don't have proof of intent to drive off into the sunset with the loaded gun in the car.
I would say that I absolutely agree that there's no proof of the intent, but there's also the overt act has to go to the actual commission of the offense. And when you have a licensed firearm holder, it's not fair to assume that they were not going to then legally move the firearm. And again, he could have gone back to the vehicle. He could have holstered the firearm, put it on his side and driven away. And that would have been perfectly fine under the statute.
Did he have a
could have taken-
holster?
There's no evidence in the record.
I thought the whole point was that he was charged with not having a holster.
He was charged with failing to holster the firearm based upon it being in the central.
Oh, I see, but he might have had a holster.
He might
We
have
don't
had
know
a
that,
holster. It
But-
might have been able to carry it.
What does
But
evidence say, had he pumped the gas already before he went into the store, or we don't know?
I don't believe that the record makes that clear.
Okay.
Yeah.
Yes.
So I just think that, I think at best the record suggests that he's sort of coming back. And maybe my assumption was that he was coming back from having paid cash for the pump or something like that. But the record does not make that clear.
So the last provision that we've not talked about is this failure to notify provision. Can we talk quickly about that?
Yes, and so I do think that the express language of the failure to notify provision, the nature of what must be disclosed, its underlying rationale, and they all demonstrate that the council here was intentionally limiting the duty to disclose to firearms that were actually on the person. And that's just consistent with the duties that are in the statute. With if a person is approached and lawfully subject to a Terry stop, then if they are presently armed and dangerous, presently armed, then they have to disclose that if they have a concealed firearm on them. And I think that the
What if
purpose.
the firearm is right within reach?
I think that, and I don't necessarily need to decide, it may have been a different issue if Mr. Williams had been co-located with the firearm.
Well, statutorily, right, like concealed pistol is defined as a defined term. So concealed pistol is loaded or unloaded pistol carried on or about the person, entirely hidden from view from the public, or on or about a person in a vehicle in such a way as it is entirely hidden from the public. So I think the answer to Judge Glickman's question is, if it's within reach, if you're in a car or if you're, if it's on or about your person, then you have to disclose it, right?
That is what the government has argued, and we have taken the argument that in reading the statute and applying the pursuant to the other regulation, the 22-4506, that limits it to on the person. But even if we take the government's argument to be, and we assume that it is an on or about provision, it is not on or about the person when it is locked inside of a vehicle and it is no longer accessible. One of the arguments the government makes is that, well, we should consider what would have happened had the police not intervened, but that simply is not supported by our case law. Our case law is clear that we must consider the actual accessibility, the actual reasonable ability of the person to reach and get to the firearm. And the other issue is that the carrying and the on or about language, that comes from our other unlawful possession.
No, it actually comes from the statutory, like if you look at the definition section of the statute, that's where I got the definition of what a concealed pistol is which is then the term. But I take your point. I don't know that arguably helps you, right? Because your point is the gun was not on or about the person, your
Yeah.
client, when he was standing there talking to the police, and he was not in the vehicle such that it was on or about him while he's in the vehicle, right? Had the police got him while he was sitting in the car with the gun in the console, I think this definition of concealed pistol would apply to your client, right?
I think that that would be a
On or about
different,
a person in a vehicle in such a way as it is entirely hidden from the view of the public.
yes.
Right, so
Had he
had the
been-
police, had he gotten into the car and then the officers had walked over to him and talked to him, he would have had to disclose the existence of the pistol.
And I mean, that is consistent with the actual disclosure requirements, which is to disclose that, yes, I'm presently armed and dangerous. And it's just weird to say, yes, I'm presently armed and dangerous because there's a firearm some unknown distance away inside.
Why is that
my
weird?
Locked vehicle.
I'm not sure I understand why that's weird.
I don't think that it meets the purpose of the statute. The
Purpose of the statute is to let the officer know that there's somebody he's dealing with who may have access to a weapon that could be dangerous.
I think that the purpose of the reason that there's a mandatory disclosure is when you have a close quarters situation where you are potentially about to be patted down or the officer has stopped you, that upon seeing a gun in a waistband or concealed on the person, that somebody may make a sudden movement and that there may be a misunderstanding and becomes a dangerous situation. But-
It would certainly serve that purpose, but that may not be the limit of the purpose.
But the underlying policy of the on or about language, and this is part of the reason that I think that it's more limited on the person than really a broad on or about, is because the on or about was about keeping firearms not accessible or away from people, I think, what you might call a hothead, or where it was easy to use. But when you have somebody with a concealed carry permit, that policy really isn't applicable to them because they've had a background check, they've done the classes. We've determined that they can lawfully.
That seems that the policy is not applicable. It's nice they had a background check, but
Well, it's not.
may I ask you a question? Do you think, setting aside, this is really for the government, I suppose, but do you think that this regulation, this requirement that that a person to whom it applies must notify the police of the concealed carry raises any Fifth Amendment issues? This was not raised in the trial court. Now, one argument would be to say, well, it only applies to licensees, so they're not violating the law. But I don't know if that's a good enough answer because the licensee could still be, they may have a license, but could still be violating the law in the way in which the licensee is carrying the weapon, or, you know, what kind of weapon it is or whatever. And it seems odd to me. I've never seen this kind of a statute elsewhere that I can think of, that the statute requires the defendant to, in effect, admit that he's committing a crime to the police officers. And if he fails to make that admission, he's committing a crime.
I guess my response would be that at best, I don't think that Mr. Williams was committing a crime.
So you don't have, if you think that, you don't have that problem here, I guess, but.
And I do see, yeah, it is sort of conditioned upon, or it seems to be conditioning his license to do that upon his, agreement to disclose. There is a strange interplay there, and I would just say that as long as it's, there is a deeper issue, but given that I think here, because he was not actually committing the offense, that it's not something that has to be addressed at this point. And then with that, I don't know if there's any questions about the constitutionality of the statutes, or I can respond in rebuttal, whatever the court's.
Give you a few minutes on rebuttal.
Thank you, and may it please the court. Brian Leach for the district. These convictions should be affirmed. The evidence proved Williams's guilt beyond a reasonable doubt when it is construed in the light most favorable to the government. And his constitutional claims, to the extent they are preserved, lack merit. The officers complied with the Fourth Amendment in stopping Williams. They complied with the Fourth Amendment as well in conducting a probable cause search of the vehicle after the open air dog sniff.
We
And
start there. I mean, just because there's so much, and I hate to interrupt your nice introduction, but you also write a nice brief, so we understand what your arguments are. But starting with the probable cause, the government isn't defending the trial court's Gantt search rationale, correct?
we did not argue Gantt below.
Right.
Yeah.
Yes.
Yeah.
So if this is an automobile search, my understanding is the government is saying that search is supported by the dog sniff evidence.
That's right.
I don't understand the government to be making an argument that absent the dog sniff evidence, there was probable cause. Is that correct?
That is correct. The dog sniff, we would agree, is critical to the.
Case rises and falls on the dog sniff.
I would say there is more evidence to support the idea of there being probable cause, but the dog sniff, I think, is what really pushes it over.
The government hasn't made, you just haven't made that argument.
That's right. Yes, that's right.
All right. So, the Supreme Court came down with this decision in Florida versus Harris. And then in the Harris case, the question was whether or not the government had to present records of the dog, performance records, like what's the data on how many times they alert correctly. And the Supreme Court said, no, as if you put in the certification evidence and the training evidence, that's sufficient. But I didn't see anything in Harris that said that the government doesn't have to put in anything at all about reliability of the dog sniff. And that's sort of where I see this case, right? Yes, the officer testifies that he observes a dog sniff occur, but he's not a handler. He says, I've seen some of these things sometimes, but what is that supposed to tell us? So there just seems to be no evidence about reliability in this case. And I'm just wondering, do you think that how do you think that squares with Harris? Because Harris seems to suggest to me that such reliability testimony is necessary. And I'll add, just key citing Harris and looking at cases subsequent to Harris, there are a lot of cases out there that seem to understand Harris that way, that, look, a reliable dog sniff can suffice as probable cause, but there seems to need to be some threshold showing of reliability that then the defense can challenge. But it's not on the defense to show in the first instance that the dog sniff was unreliable. The government has to put in the evidence that the dog sniff evidence was reliable.
So a few points. There's a lot to unpack there.
But yes.
Two initial responses. The first is, this really goes to an issue of foundation for the officer's testimony about probable cause. Just like any other issue, if a defendant doesn't challenge the foundation for testimony at a hearing, that objection is forfeited.
He objected.
He did not object to the reliability of the dog sniff in any part of the lower court's record. There's no part of the lower court's record where you will see an objection to the reliability of the dog sniff. So you let the testimony go forward. This is the definition of sandbagging. This is letting the government put on a case and then saying, you didn't present evidence when we could have if he had just raised the objection.
Isn't it the government's obligation in the first instance?
So this is my second point
Right.
about Harris. Yes.
Okay.
So this is my second point about Harris, is I think Harris stands for a broader principle, which is that dog sniffs are to be treated like any other probable cause hearing. And whether it's a dog sniff or a human informant or the officer, him or herself testifying about what they smelled emanating from the car, the officer's testimony, like any other witness, is presumptively credible and probative unless or until there's an objection presented to the foundation, or whether it's, hearsay or something like that. But here we have nothing of that sort. Here's what we do know, though. We know that.
I'm just going to quote from Harris for a second, and it says, if the state has produced proof from controlled settings that a dog performs reliability in detecting drugs, and the defendant has not contested that showing, then the court should find probable cause, right? And the government has the burden. The government has the burden to put on that arguably that the dog sniff is reliable. Then the defense can challenge it if they want to, but if the government doesn't put any reliability evidence into the record, why does the defense have to cross on that?
There is evidence, it's the officer's testimony about what he observed.
Okay, but
that
that's
is
not
evidence.
reliability. I
No,
mean,
no,
I'm sorry,
no,
like
no, but
really,
Harris
like,
is not
look
setting-
at,
Yeah.
right, an alert, this is, or an Oregon appellate court says, an alert by a properly trained and reliable drug detection dog can provide probable cause to search. There's no evidence about this dog's training. And I know that the court makes a finding of fact, says in its order that the dog is trained, but there's no testimony. I mean, that finding is clearly erroneous because there's
Not
no
at all, not
testimony
at all.
about, there's no testimony about training.
There is testimony that the reason they called the canine unit was because they had serious concerns about a weapon in the vehicle. The only way, the most plausible
They
inference.
contracted a canine to do a sweep of the vehicle. Okay, that's what they did.
Oh, at page
But
24,
there's,
at page 24 of the transcript, he says, we called the canine unit because we were concerned about a weapon in the vehicle. The most plausible inference is they
but
called a
we have no idea
canine.
who showed up. I mean,
Sorry?
I mean, sure, they contacted the canine unit. We have no idea who the canine unit sent. Was this a dog who's the first day on the job? Was this a dog who hadn't done any training for years? Was this a dog who never got his certification? Was this a handler who had never done this before? Like there's no information in the record. And if you look at all the cases, I mean, it just like all the evidence that comes in these dog sniff cases around the country in state and federal court, you've got the government producing training records and putting the handler on the stand and presenting certifications. And,
Sure.
all of that stuff comes in the government's case, and then the defense tests it. But none of that, I mean, this is just like the barest of bare, like there's nothing there.
Harris is not setting an evidentiary floor. The facts in Harris did involve different types of certifications
Doesn't
that are
set an
provided.
evidentiary
No,
floor,
it
but
says
it
that-
does say that similar to every inquiry into probable cause is whether all the facts surrounding the dog's alert, viewing it through the lens of common sense, would make a reasonably prudent person
Which
think a
does not
search would.
require evidence of
No
reliability.
idea why a reasonably prudent person would think that this dog was a reliable drug sniffing dog.
Because it's reasonable to assume that the Metropolitan Police Department of the District of Columbia is sending out qualified dogs based on.
Then you could just assume that in every case, that everything that the government does to collect
No, not at all.
evidence was
Not at all.
reasonable and reliable, and that the government doesn't have to prove it. And the government has to put its evidence forward, its cards on the table, so that the judge can assess it, right? And it just didn't do that. And then the judge didn't do his job to actually consider, is there anything here for this drug
Does it-
sniffing dog?
Could I just interject here and see if I understand something correctly? Does it make a difference, in your view, whether the defendant, when this testimony about the dog sniff is presented, does not object to and does not argue to the court that this did not provide probable cause? Does that make a difference here?
Yes, in our view, it certainly.
In other
does.
words, suppose, for example, the police officer comes upon the car and there's this random dog. And this random dog is jumping up and down, barking at the car, and that's all we know. And the officer says, tells the judge, well, that was happening, and I thought that meant there was a gun in the car, and I looked in the car, and lo and behold, there was a gun in the car. And the defendant makes no objection to any of that testimony. Is the judge, is it your position that at that point the judge can say, okay, well, it's admissible? And I find that in the absence of any objection by the defense, there was probable cause for the police officer to think there was something in the car. Is that what we have here
No,
or
it
no?
is not. No, and this, the distinction between that case and this one, there are many.
Well, here we have a presumptively validated dog. The dog works for the police.
But I would say.
He hasn't been
If
fired.
there are questions about
Whatever.
the training of the dog, we know that the dog was called because there was a concern about weapons, not a concern about drugs, but a concern about weapons. It's reasonable to presume, and I should say it's reasonable for the trial court to infer that the MPD sent a qualified canine unit for detecting firearms. That was the entire purpose for calling them. It's also, we know that this officer did have experience with other canine units at arrest
I
scenes.
think that's stretching it to say he had experience. He said that he had seen other dog sniffs before. I mean,
Yes.
I have seen people doing road work on my street. I don't know how to repair a pothole.
I'm not
right?
saying he knew how
I
to handle the
just-
dog. I'm
that-
saying he knew what he was looking at.
No, he doesn't say that. I mean, he just says, he just doesn't say that. But to the point of whether or not counsel objected to this testimony, we're not talking about whether or not this testimony was admissible. It was relevant. It was admissible. Sure, he could say that he saw the dog sniff happen. The problem is the government had the burden to show that there was probable cause for the automobile search and had to show that this dog sniff was reliable. And they put in zero evidence. And, the defense counsel does say at the outset of the hearing, right? He recites the fact that, this is what the government did, and they brought a dog to the scene, to sniff the vehicle. And then he says, our argument is that the police did not have probable cause to search the vehicle. Like, he makes it clear that not the dog sniff notwithstanding, there's no probable cause. The testimony comes in. There's no argument after the hearing because apparently the judge doesn't want to have argument, which is an interesting choice. And then the judge says there's probable cause. So, I'm not quite sure how we get to, it's the defense's fault that the government didn't put on evidence that would amount to probable cause.
Even in Harris, the defendant in that case forfeited an objection to the adequacy of the dog's training. So the same logic applies here. What Harris stands for is a proposition that probable cause analyses proceed the same way for dog sniffs as they do for other types of testimony that would be offered in support of probable cause. If there is no objection, that can't be argued on appeal. The objection has to be made at the time. And I don't think what he's
If-
argued was
Take
enough.
Judge Glickman's example,
Mhm.
where
It would-
the
that-
government puts in evidence that there was a random dog jumping at the car door, and the officer understood that to be, reason to think that there was a gun or drugs in the car, and he made the search. And there's no objection to that testimony because the defense counsel thinks that's ridiculous. That's not probable cause, and just maintains their position of there is no probable cause. Do you think there's some sort of forfeiture by the defense when they come up on appeal, when a trial judge has said, well, that was probable cause? I didn't allow any argument after the hearing, but that testimony sounded good to me. Do you think there's a forfeiture by the defense to say, no way on earth is that evidence, reliable or probable cause?
What I would say is, in this case, there is evidence about the reliability of the dog because we know.
I understand you
Right.
think there is, but I'm just asking you, do you think that there's some sort of forfeiture?
I think that there might be a forfeiture. I think it would also be plain error though. I think reversal would be appropriate in
Why
that
is it
circumstance.
plain error. I mean, this seems like an E versus Escondido sort of thing. Like the defense counsel is saying government has to show probable cause, right? And they haven't shown probable cause. Whatever they're telling you, it's not probable cause, including the dog sniff, not probable cause.
Facts of the hypothetical are sufficiently absurd that I think any court, including this one, would.
Yeah, I'll
reverse-
withdraw my hypothetical.
that any court would reverse I don't mean to insult the hypothetical, Your Honor, but I think any court would reverse in that circumstance.
Stating hypothetical, and I'm just, the difference between that hypothetical and this case,
Sig-
where some dog,
It is not
from-
simply some dog, Your
well,
Honor. It's not a
some
random
from the
dog.
canine unit.
Okay, this is a critical distinction.
About which we know nothing. I mean, we really know nothing other than it is a dog with the canine unit.
We know
But
that it
we,
was called in response to a concern about
Sure.
firearms. We know that it alerted to a firearm. I mean, I'm not trying to, I don't mean to get into hindsight
but
analysis.
we don't know what the dog's training was. We don't know whether the dog was certified. We don't know anything, right? Like Harris says, okay, you don't need performance records, but if you've got records of training and certification, that will be probable cause. There's nothing in Harris that signifies, well, if you don't even have that, if you just say a dog from the canine unit showed up and alerted, that's enough. And certainly the cases around the country show that, police units are doing a whole lot more to substantiate a dog sniff, the reliability of dog sniff, than happened here.
It's very likely we could have done the exact same thing had the issue been raised by the defendant in his motion to suppress, or in his initial argument, or at the hearing, or in his, even in
The
his.
motions to suppress are always bare bones because, nobody knows what's going to come into evidence. And so the government has to front load its case. And
That may
if the
be-
government doesn't front load its case, it seems like the defense can be like, well, I didn't put any of the evidence here, so I don't have to say anything.
No, I think the idea that the defendant
I
doesn't
mean,
have to say
shouldn't there
anything
have
at
been
trial when there's.
argument at the end?
Help me out here. What position did the defense actually take at the hearing on the question of the significance of the dogs alerting?
As I read the record, none. There were vague arguments about, this is a trial transcript 10 to 11, I believe, is when he actually presented argument before evidence was heard. And there were vague arguments about the lack of probable cause. I don't recall any mention of the dog sniff in that
Reading on
argument.
page 11.
Sure.
Then the police, roughly within about 45 minutes or so, had the dog sniff the vehicle. Then it talks about the police recovering the firearm. And then he says, our argument is that the police did not have probable cause to search the vehicle because they didn't have probable cause or reason to believe there was a firearm in the vehicle.
And that is not an objection to the reliability of the dog sniff. I don't know how that could be. I don't know.
It's an argument that there's no probable cause
Sure.
based on the dog sniff.
No one's disputing that there was an argument that probable cause had not been established, but he didn't raise this argument about the idea, like the trial court could not have possibly been on notice that he was raising a Florida versus Harris argument about the adequacy of the dog's reliability.
What did the government say about the dog's reliability? And I mean, how did the government answer the defendant's point? Help me out on that too.
Well, we didn't have an opportunity because the argument was never raised. But here's what the record does show from the officer's testimony. They were concerned that there was a firearm in the vehicle because Williams had repeatedly said that he was a law enforcement officer, and he was really evasive and visibly nervous when they asked about weapons or anything illegal in the vehicle. So they called a canine unit. The canine unit arrived. Now, our view is it is a perfectly reasonable inference to draw that a qualified canine unit, a firearm detection dog, showed up in response to that call.
There's no evidence that he's qualified. I'm sorry. There's just no evidence that he's qualified. He works for the canine unit. There's no evidence of qualifications.
Right. And I think it's a reasonable inference that the Metropolitan Police Department of the District of Columbia is using qualified dogs and not, as my friend suggests, untrained puppies. That is not a plausible inference from this record. I would acknowledge, I wish we had put more evidence in. I wish that because we probably could have, but the point is it was never presented to us at a time when we could have made a record on it. That's the critical point. It's one thing to argue an appeal and say, well, the record's really unclear. But if you never raised the objection and gave the government a chance to put to its burden of proof, I think it's hard to say that the government made some sort of egregious error in this case, or the court made some egregious error in holding that there was probable cause
So
based
do you
on the
think
officer's
the
testimony.
government really had no incentive to put the evidence on? Is that what your point is? No incentive to, beef up the reliability evidence?
No, I think, to be frank, I think it's candidly, it's always the prudent courts to, as Judge Easterly suggested, front load the argument and front load the presentation. Our point is simply that if there is a perceived flaw or something, some shortcoming in the presentation of the government's evidence, and it's being raised for the first time on appeal, I think you can review that for plain error and reject it. But I do want to,
So you're right. In other words, your point is, it's true the defense counsel said, Judge, this does not amount to probable cause. But there was no explanation from defense counsel saying, and the reason is because there's been no evidence as to the reliability of the canine.
yes, and even in his proposed findings of fact after the hearing, he mentioned the dog sniff in one sort of throwaway sentence, but otherwise does not challenge the reliability and doesn't say anything about the testimony of the officer or a lack of records or lack of certifications or anything like that.
We pursued this quite a bit. Could you explain something to me? What is the grounds before there is probable cause determined in that manner? When the officer does not have probable cause, what is the legal basis for the officers detaining the car at the gasoline station rather than letting I think it's his girlfriend, Appellant's girlfriend, drive off in the car, or for that matter, Appellant's, but
Well, yeah, Williams has not challenged the legal basis for holding the car while.
I'm not sure it's been challenged, but I've been wondering about why. See, there is this argument that, well, it's danger. I thought about this because the government makes its argument in the brief that, it would have been dangerous, or the police officer thought it would have been dangerous to allow somebody to be driving a car with that degree of tinting. But I don't think that was actually the reason that or that there's any evidence that that was the reason that the officer detained the car. And I've been wondering whether there was a Fourth Amendment issue in that detention
Well,
prior to the establishment of probable cause.
sure. I can't answer that as I stand before you because the issue hasn't been briefed. I do apologize for not having a case ready at hand. My understanding is that the officer said that, we needed to tow this vehicle. I think what he was suggesting
It
was that.
seems very odd that they were, well, all right.
Yeah, I think,
Right.
I think what he was suggesting was because of the vehicle tint and potentially other safety issues with the vehicle, having the license plate not being properly displayed, that this was a vehicle that they could not let someone else take out on the road. Now, I know there are concerns about, well, was there proof of a violation of the window tinting law? And I think there's a bit of a catch-22 in this, because as I understand it.
If they were going to tow the vehicle, they didn't need to call the dog and all the rest. They could just tow it and we'll deal with it later.
Right. As I understand it, as I understand it, to test the window tint, you actually need to lower the window. And so you need access to the vehicle in order to do that. So there was a difficulty that the officers were facing and the inability to test from the outside in order to confirm that the vehicle was.
None of this is in the evidence.
No, none of this is in the record. And I do
Right.
apologize. I don't mean to go outside of the record. I was just trying to provide additional context.
Right. And I mean, the officer doesn't talk about the tint as the reason to tow the vehicle. He suggests that it has to be towed because it's at the pump.
Let's.
Right. But right. And if that's the reason, Mr. Williams's partner is there and saying, I would like to take the car. And there's no evidence that she's told that she can't take the car because of the window tint or the license plate. And in fact, Mr. Williams says, if the car were inoperable, like I would have towed it myself, like, or she could have gotten a tow truck to tow it away. But like the argument that it had to be towed by the MPD seems unsupported.
Well, what the officer said was, you're right. It was immediately at the pump. They needed to tow it. I think there's also a fair inference from the record, though, because there was a suspicion about the window tinting. And the window tinting is a safety issue for the cars. It's not just a regular old
But
traffic
so
violation.
Mr. Williams or his partner could have gotten a tow truck to take it immediately to the shop to get the window tinting
But
corrected.
I'm not aware of any legal requirement for the officers to allow nothing required the officers to do that. MPD policy gave them
I'm not aware of any
discretion.
legal basis for them to seize the car. I mean, it just seems like a
Oh,
civil
well,
forfeiture, like
no,
you lose the car, we take possession of it because.
The window tinting
illegally
statute,
tinted.
the window tinting statute allows for the officers to take possession and tow the vehicle if there is a violation. Now, I acknowledge we don't have proof in this record of the factual violation. But I think part of the problem, though, is this issue about, well, how would they test without access to the vehicle? So I think it was a very difficult situation for the officers on the scene. I'm happy to address, I see that my time is.
Could I ask you to address another question before you sit down? One of the conviction that I think I have the most um, uh, doubt about perhaps, is the conviction for failure to notify of concealed carry. I take the government's point that if the gun was, of convenient access and within reach of appellant, then he's subject to that statute. It didn't have to be on his person for that statute to apply. I'm prepared to accept that argument for at least for the sake of discussion. But I'm not sure it was really within, when he is outside the car with the police officer and the gun is inside the locked, apparently. But whether it's locked around, it is inside the car. I'm not sure it rose to the level of being convenient to convenient access and within reach, within the meaning of carrying, as our cases have normally talked about it. And that's wholly apart from the Fifth Amendment question, which I asked, which nobody's raised, but I actually am interested in. So if you want to comment on that too, that would be good. I'd appreciate hearing what you have to say about that.
The convenience of access and within reach standard looks to the substantiality of the obstacles to obtaining the firearm. Now, in this case, the officer's testimony was that the center console was freely accessible to anyone with access to the vehicle. Williams had access to the vehicle, and according to his own testimony, he had just returned to the pumps where the car was immediately standing next to the pumps. So he was right next
Where
to the
was
car.
he standing when he's talking to the officers?
It's not clear, but I think viewing the evidence in the light most favorable to the government, I think it's reasonable to infer that he was standing very close to the vehicle.
How close?
I
5 feet?
I don't know.
10 feet?
Well, under this
Feet?
court's decisions, it could be 18 to 20 feet away and it would still be within his reach. So the concept of within reach,
But-
not within
But
immediate reach.
But within reach, I mean, it's in the console in the car,
Yeah.
right? So it's like two things have to be opened for him to be able to get to it.
Right, but he had the key and no car is designed to be difficult to open for the owner.
But I'm
of the
just
key.
wondering, do our cases stand for that proposition? Assuming that this convenient within reach, because I have a question about that standard applies to this statute, because that comes from interpreting carrying in a different statute. Do we have cases that say that you have to open you'd have to unlock the door, open the console to get to the gun? That's what our
I
cases.
would say that your cases do not foreclose that. I would acknowledge there.
So we would be
Henderson is-
expanding to say that.
No, I don't think it would be expanding at all. I think what you would do is you would look at convenient of access sort of essentially means proximity. And then within reach means could this person reasonably access the firearm from where they were at the time of the stop? And when
So my
18 to
question-
20 feet away in Howerton was within reach. In White, it was several feet in the back of an ice cream truck in a box.
My question then is about the definition of concealed pistol. Because it seems like that kind of takes us out of this expansive understanding of carrying in the criminal context, right? Because the legislature was pretty clear about, okay, well, when we're talking about a concealed pistol, what we're envisioning is something that's on or about the person or on or about the person in a vehicle. Right, so it suggests that we're actually talking about this sort of more limited scope, right? So he's not in the vehicle, so it's not on or about the person in the vehicle. He's outside of the vehicle, the gun is in the vehicle, it's in the console in the vehicle. It just seems like this arguably doesn't satisfy the definition of concealed pistol under the failure to notify statute, no matter what carrying may generally mean in a criminal context.
So I
And
understand.
it's the
question.
government that's
Why-
bringing up this definition, and I appreciate that the government did, but it seems to suggest this concept of
Yes, we-
having the gun close to you.
We read those two clauses as doing different work. The second clause relates to a situation where the individual is both in the vehicle and the firearm is in the vehicle.
Right,
The first clause encompasses situations where the person could be outside of the vehicle or the firearm could even be inside the vehicle and still be within reach or convenient of access. If I could offer just an
Doesn't make a
example.
whole lot of
No,
sense,
if I could,
though,
I think
because
an
if-
example
if
might
it's
help to
talking
illustrate the
about-
point.
Well, okay, I'll get the example, but I just want to point out like that if the phrase on or about a person in the vehicle puts the person and the gun in the car. So it seems like the first phrase is when the person and the gun are outside of the car. The second is when the person and the gun are inside the car. But you want to say that the first part applies to a person outside of the car and the gun in the car, and that seems in serious tension with the definition of.
No, I don't think so. Again, I think the example may help. There could be a situation where someone, imagine a tailgating party, where someone's sitting on an open trunk. They're sitting outside the vehicle, but they have a firearm stashed up underneath the hood of the trunk. The trunk is open. They're outside of the vehicle. The firearm is inside of the vehicle. There are situations where it will be, a person will be outside of the vehicle, the firearm will still be within their reach, within the vehicle. And so to take the facts of this case, if Williams had said, oh, you know, my ID is in my car, let me open it up. And so he opens up the door. At that point, there's no question that the firearm is on or about his person, even though he's still outside the car.
Sure, once he opens the door.
And he's not, but I'm saying in the situation.
Then his duty to notify would be triggered, right?
don't think
Like if
this-
he approaches the car, opens the car and gets close to the console, then, then he is in the car, right?
No, what I'm saying is, I think if the officer stopped him and said, no, don't worry, and he doesn't go actually inside the car, I think it becomes clear he would be outside the car. I don't think anybody would question the idea that the firearm was still within convenient of access and within reach. Our point is simply that the distinction between the door being open or closed is entirely arbitrary from the perspective of the statute's purpose, which is protecting the safety of licensees and police officers during these types of stops. What the legislature did was it made a policy judgment that when it comes to firearms in the presence of a concealed carry licensees, that ignorance was not bliss for the officers. They wanted the officers to have that information so that they could respond appropriately, because when a firearm, even if it's just a few feet away in a locked vehicle, changes the calculus of the stop for both parties. And it could easily lead to a situation where you're faced with ambiguous conduct that the officer now feels threatened, the person is unsure of what their standing is, and it's a dangerous situation for all parties involved. So I don't think that
So
this.
if he had been outside of the vehicle and the gun had been in the lockbox in his trunk, do you think that he had a duty to notify under the statute?
If it would depend, Your Honor, it would
Why?
depend on a number of things.
Why? He's
Because-
still, I thought he would still be, he's in the same physical position that he's in, that you think that we need to infer that he's in. So he's,
Sure.
right?
Yeah.
Same physical position, it's just that the gun is in the lockbox. Why does he have a duty to notify? Why wouldn't he have a duty to notify?
Well, it would depend on exactly how many steps there were. And how many-
Same number of steps,
Same number of steps. Well, then
same number of steps.
I think it potentially could, although I would acknowledge that there are ways for licensees and regular gun owners to lawfully transport their firearms.
We're not
in
talking about the
district.
transport
Right,
statute.
but
We're
I'm trying
talking
to-
about the duty to notify statute.
Right.
So I just want to know, Mr. Williams is standing in position X that you think is close enough for him to trigger the failure to notify in this instance, when the gun is in the console.
Yes,
Change the facts only to
Mhm.
the gun is now in a lockbox in the trunk, but he is exactly the same distance away, still has the key to the car. Why wouldn't he have, I would have thought your answer had to be yes,
Yes,
he
my-
absolutely has to notify. It would be illegal for him to fail to notify the police officer that he has a gun in a lockbox unloaded in the car.
Yes, and thank you. And with the additional clarification in your question, yeah, my answer is yes. It would still be given these circumstances, even if it was in a lockbox.
I want to raise a hand on that and say, this to me suggests some troubling ambiguity in the definition of convenient and ease of access. And I'm, when we're talking about a criminal statute, somewhat uncomfortable with that. Do you think there's a Fifth Amendment privilege issue here, lurking here?
And I meant to get back around to your question. So first off, the issue's not been briefed, so as I stand before you, I can't.
Excuse me, I'm sorry, I didn't
The
catch
issue,
that.
the issue has not been briefed.
No,
and
I-
argued, and so as I stand before you, I don't have a fully formulated answer. As my friend suggested, I think one potential.
I'm flagging it so that you and the city council can go and fix this regulation, which I regard as troublesome in a number of respects.
I appreciate that, Judge Quickman. I think as my friend suggested, This could be viewed as a condition of the license, the disclosure requirement. And so in that sense, it could potentially be constitutional. But I would acknowledge if the court has serious concerns about that, we would not defend the statute if it's obviously, if it needs to be read more narrowly to avoid a Fifth Amendment self-incrimination problem. If the issue were properly presented, we obviously, we're not asking the court to apply the statute unconstitutionally. So,
Well, I mean, that may apply here then. Might it not?
well, I think it would be more prudent to wait for a case where the issue has actually been briefed. And as I say before you offering this
Right,
response, I can't say that this is the district's, fully formulated position on the issue. I'm happy to address any other questions the court may have on any of the other issues.
I have lost where we are. Have we talked about the failure to holster?
I don't believe so, Your Honor. No.
I mean, it just seems to me that this, this regulation, it's impenetrable. But it seems to me that the district's argument relies on us inserting some commas into the regulation. And in fact, it was incompletely quoted, the regulation in the district's brief, which I sort of raised my antenna. Right, the regulation says a licensee shall carry any pistol in a holster on their person. And I think that's where the district stopped quoting. But it actually says in full, a licensee shall carry any pistol in a holster on their person in a firmly secure manner that is reasonably designed to prevent loss, theft, or accidental discharge. And it just seems to me it could be read either a licensee shall carry any pistol in a holster, comma, on their person, comma, in a firmly secure manner, or it could be read as a licensee shall carry any pistol in a holster on their person in a firmly right? Like it's if the pistol is in a holster on their person, it has to be carried in a firmly secure manner so that somebody can't grab it, right? But I'm just not quite sure what to make of this regulation.
I understand. We view the two provisions to work together, serving different functions. In point one, it's referring to how you would go about, how you must conceal the firearm, which is to say it must be entirely hidden from public view. And then in the second provision, it's explaining how you must carry it. And we read the language to suggest that if you are carrying the firearm, it must be holstered in a holster on your person, firmly secured to prevent
Right, with the
accident.
commas.
Yes, essentially, yes,
Yeah,
that's right.
But the commas aren't there.
Neither is it written the way Your Honor suggested on the alternative. I think with or without the commas, I think that, the punctuation is ultimately not going to be dispositive on the meaning of the statute or the regulation. I think it's more important to look, at the context of the regulation and what it was attempting to achieve, which is preventing accidental discharge, loss, or theft of firearms that are being carried by licensees. And in that sense, the easiest way to achieve that is to require people to be carrying the firearm on their person in a holster.
Well, but if you don't put the commas in, right? I mean, if arguably to say a licensee shall carry any pistol in a holster on their person, that means that they can't carry it in a lockbox.
So
Right?
this regulation has to be read in conjunction with 224504.02, which in subsection D and E, I believe, allows licensees, concealed carry licensees, to transport firearms concealed on their person. They don't have to put it in a lockbox. It can be concealed on their person as long as it's, in compliance with this regulation.
I'm not talking about the transportation. I mean, I get that, right? There is this exception to the unlawful transport, right? That they can carry it concealed on their person when they're transporting it, if they've got the license, the concealed license. But the regulation, arguably, if the regulation says you'll carry any pistol in a holster on their person, suggests that that's the only way to carry it.
Again, I think
I mean, that would be wrong.
those two provisions have to be harmonized. And in order to harmonize those two provisions.
I'm not sure what, like this, I thought we were talking about the unlawful transport says that you can carry it on your person, right? So this is saying you have to carry it on your person. You can't do it any other way. I don't understand the harmony argument. Maybe I'm missing something,
No.
like this.
The district's view is that when someone is transporting the firearm, so let's imagine a licensee puts their firearm, unloads it, puts it in a lockbox separate from ammunition. It's not immediately accessible in the vehicle. When they're doing that, even if in a general sense, they may be carrying it in the car, the district's view is that you are transporting it lawfully and would not be in violation of the holster regulation, because transporting has a potentially different meaning than just carrying, even though I would acknowledge as a colloquial matter or in sort of common parlance, we might say someone is carrying the firearm in a vehicle, even if it's in a locked trunk. But the way the district reads these provisions is that if you are transporting it in accordance with 224504.02,
I
you're
get
not in
that.
violation of the holster.
I'm sorry, I'm not, I think I'm just keeping us in circles, but I understand that under the district's view, someone with a concealed carry permit can either keep it on their person while they're transporting it, or they could behave like someone who's not a concealed carry licensee and put it in a lockbox unloaded, right? That's fine. My concern is with the failure to holster provision, which suggests that at all times you're supposed to be carrying your pistol in a holster on your person
We would,
under the district's reading.
right, we would suggest that while it's being transported in accordance with 224504.02, you're not carrying it within the meaning of the holster regulation. So it doesn't need to be on your person in a holster. That's how we have harmonized these two provisions. I'm not sure I can give Your Honor a better answer to this
Okay,
question. And I apologize that I'm not able to close the
Okay,
loop on this. But I think when you look at these regulations together, what it shows is that the district has provided concealed carry licensees like Mr. Williams the opportunity to carry their firearms in public in the most readily accessible manner possible, which is directly on their person, even loaded, even in a vehicle. The fact that he chose not to comply with those regulations in this case, I don't think is a reason that his conviction should be affected.
What is the government's position on how much, if any, wiggle room there is for the transfer from the vehicle to the person's body?
Sure. Our view would be that if someone is engaged in an act that is predicate to complying with the holster regulation or with the transportation regulation, so if they're moving it from the holster into the lockbox lawfully, or moving it from the lockbox into the holster, we recognize momentarily it's not in a holster. That's fine. If it's an act predicate to complying with the statute or the regulation, that would not be viewed as a violation. And we're talking about more situations where someone is holding it and putting it in their backpack or their
in
purse.
this case, there's no evidence that he was doing that.
Well, there's evidence he moved it from the lockbox.
There's no evidence that he didn't move it from the lockbox to the console out of the holster.
Right, there's no evidence he had a holster on him at all. And I think the inference that can be drawn from that is that he did not have a holster.
There's no evidence that he didn't have a holster on him.
This is true. I think it's a more plausible inference from the absence of evidence that he did
Just
not have a
seems like
holster.
it's completely
Well,
speculative.
he was carrying it in the console. And that's clearly a violation since the console is not a holster.
Well, yes, there are two theories. One is that it was carried in the console. The other is that it was moved from the back and carried. I would sort of underscore that when it comes to sufficiency review, we don't need to negate every potential inference of innocence. We just need to provide, evidence.
I'm just trying to understand the meanings. Does under the transportation statute, does the government agree that transportation requires movement or no?
Yes, I think we would agree that transportation means moving from one place to another. Yes.
So if it's just in the console and the car isn't moving, the transportation statute hasn't been violated.
If it was found that way, yes. Of course, as Your Honor noted earlier, the officers saw him drive the vehicle into the gas station from a public road. So we know the vehicle was being transported.
But his testimony is it was in the lockbox when it was in the back of the trunk, and there's no testimony about whether it was loaded or unloaded.
Well,
Are we supposed to assume that it's loaded?
No. What you can do, though, is draw a reasonable inference from his testimony that all he did was move it from the lockbox to the center console. And I think, as Your Honor suggested earlier, the state in which it was found, it's reasonable to infer it was in that state from the beginning. It's a pretty critical detail for him to leave out, this idea of, well, when did I load it? I think the fact that all he said repeatedly was he moved it from the lockbox to the center console, and there's no evidence to support a contrary inference, I think suggests that the trial court could have reasonably inferred as a finder of fact that the firearm was loaded as it was being either transported in the back of the truck or, as I said earlier, that potentially there was going to be an attempt to drive it away with the firearm in the center.
Isn't it,
console.
and I think as your opponent says, an equally reasonable inference that a law enforcement person or a security guard, or whatever, would have complied with the requirements, and so it would have been unloaded.
I don't think it is an equally plausible inference, but even if it were, when there are two different versions or two different ways to reasonably construe the evidence, what this court has held is that means the judgment should be affirmed. And the trial court, as a finder of fact, was entitled to draw the inference one way or the other. So I think that the more plausible inference is that the condition in which the firearm was found is the condition in which it had been the entire time. Like if Williams had never testified, the only thing we would know is that the firearm was found in the center console loaded. And from that, the trial court could have inferred that, well, I think it was in the center console the entire time.
And does it matter that he's never crossed on this? The government never challenges this testimony.
I believe the government did cross him on him moving the firearm. And what he said was it was not on his person when he left it. And he said it was loaded. I would acknowledge there's some ambiguity.
Doesn't cross him on, sorry, I'll be more specific on the fact that he said that it was unloaded in the trunk.
He didn't say
it was unloaded, that it was in the lockbox in the trunk.
we crossed him about that and he told us the same story he told on direct. I think this is at page 55 of the transcript where there's a discussion about, okay, what did you do once you got to the gas station? And his testimony was that he got out, grabbed the firearm, moved it to the center console. We asked, was it holstered on your person at that point? He said no. And was it loaded? He said yes. And so, I think reading that evidence in the light most favorable to the government, the trial court absolutely could have inferred reasonably that he was saying that the firearm was loaded when he moved it. He did not load it before moving it. And so that would, I think, establish a violation of the transportation laws. And
Okay, so just to be, so I understand, the government accepts that he did move the gun from the trunk, from the lockbox to the console, but says the absence of evidence as to whether or not he loaded the gun should be held against Mr. Williams.
we think, no, we're not holding any evidence against him. What we're saying is the trial court could have inferred from what he affirmatively said that he moved it in the same state in which it was found, that he moved it when it was
He
loaded.
says that.
I would acknowledge that if we were to relitigate this case on appeal, there might be different trials of fact that would reach different judgments. What I'm saying.
No, I'm just on as to what because I think what he said is important and then you draw inferences from what he actually said, right? I don't think he said he moved it in the same state.
No, I'm saying that's an inference that can be drawn from what he did say.
Okay.
All he said was he moved it and it was found loaded.
And the government has not challenged and seems to concede that he did, right? Like the government could have taken the position of, we don't believe that he actually moved it. We think that the gun was in the console the whole time. But the government has not made that argument.
We don't believe it's necessary to take that position. I think that if Your Honor was asking, I think, could the trial court have simply discredited this aspect of his testimony? I think potentially yes. But either way, I think the evidence shows that based on what he did say, even taking it as true, there was still evidence to support the inference that
I mean, it's kind of like with the dog sniff, the court could have discredited it, even though the government didn't attempt to discredit that part of the evidence.
Sure, that's fair. I will.
Okay.
Sure.
Oh, are you guys done?
We're done.
Okay, can I ask you, going back to something you said about two reasonable inferences, is it right that if the evidence is sort of in equipoise and a reasonable inference consistent with innocence, there's a reasonable inference that could be drawn consistent with innocence and a reasonable inference that could be drawn consistent with guilt, that if the trial court chooses guilt, the one that consistent with guilt, that there's sufficient evidence of that?
It depends, Your Honor. So two responses. What this court has said is where there are two reasonable inferences that could have been drawn from the record, this court is without power to second guess that judgment. That's what this court said in multiple cases, including Roberts, which we cite. But I think that
Maybe that's when.
Maybe the easier, maybe the slightly better way to put it, and maybe more accurate in practice, is to say that if there are different inferences that could be drawn. If you're looking at one inference, the contrary inference from what the trial court found, and there's no evidence to support that inference, it can be discounted. And I think the Evans decision that we cite about attempt liability underscores this point. What the court did there was it didn't hold the absence of evidence against the defendant, but it did consider the absence of evidence related to constructive possession in finding that he was guilty of that offense. There was affirmative evidence, and from that, you could infer that this was the only person that lived in the apartment. This was the only person that had access to the gun. And what the court said was, and there's also no evidence anyone else visited the apartment, no evidence that anyone else had property there, no evidence there were women's clothes there. So from that sort of collection of affirmative evidence, as well as the absence of evidence supporting contrary inferences, this court affirmed the conviction. I think the court could do the same thing here with these convictions.
Yeah, I guess I was thinking of a situation where there really is nothing in the record that supports one over the other. You know, I think we have sufficiency cases talking about if there's really no basis for picking A over B, picking either one of them can't be sufficient.
What I would say is that this case is more of a case where there is evidence to support the trial court's inference. There's no evidence to support the contrary inference that he did something other than what he had said. The trial court could infer based on his testimony, his affirmative statements, that what he did, what he said he did was all that he did. That's a fair inference. I think it's entirely speculative to say, well, he could have also done something else. It's no different than a situation where when someone's found if someone's found with stolen property in their possession, there's a general inference that they were the person who stole it, even if it's possible someone gave it to them or they found it somewhere. And I think the similar type of inference could be drawn with this evidence. And
We've kept you up here an awfully long time.
if there are no further
Thank
questions,
you.
I'll ask you to affirm.
Oh.
Thank you.
Thank you very much. Mr. Clark, we will start with 3 minutes and see how you do.
Yes, Your Honor. And so I'll very briefly, I just wanted to address the MPD policy. In this case, as far as the tow, and MPD policy would not actually have allowed the police officers to tow in this circumstance. The general order 602.01, it says that when a person is arrested for a crime while in custody of a vehicle that is not needed for evidence, members shall ensure that the vehicle is released to a person authorized to take custody, and then comma, secured and legally parked or inventoried and towed for safekeeping. So it is one of the ors, but then it says that has to be done pursuant to another order, which is 303.03, and that lays out the grounds for when the MPD can actually impound and tow a vehicle. And specifically, it says that when it's there's a number of provisions, but each one of the provisions basically says that if it's an issue of prisoner property, then members are authorized to tow a motor vehicle for purposes of safeguarding prisoner property only when the prisoner consents or is incapable of making other arrangements. And clearly he had his wife on scene and he had already made other arrangements. Similar issue with the traffic violation. It says that the police are not allowed to tow for a traffic violation unless it's required to be towed to an inspection station. And then finally, and I think this is maybe the most important part, it says that when a vehicle is located on private property, it's not MPD's responsibility. We don't tow. We leave it on private property. And because this is a gas station.
The general order is being cited to us in the briefs. Is that?
It is cited in my reply brief. I know that the government cited in their initial brief the general order, which is the 601, and then I followed up in my reply brief to say, well, but 601 cites to 303.03, and so it is in there. And so actually, under these circumstances, I would say that the police could not have towed the vehicle. I think that what the discussion with the district here and the ambiguities in the statute show is that there are genuine ambiguities in the statute, that it is very difficult to harmonize with the others, and that where there is this general genuine ambiguity, the rule of lenity comes into play. And that I would ask the court to seriously consider that in potentially reversing Mr. Williams' convictions. And then finally, the issue of inference. And I would say that the difference between an inference and sort of speculation is that speculation is when we have nothing to say one way or the other, and that we call that speculation. And I believe that that is what the district is engaging here. An inference is really built upon a solid set of facts, and that what is occurring is inference, is speculation. And with that, I would ask the court to reverse the convictions in this case.
Thank you very much, Mr.
Thank you.
Clark. Thank you, Mr. Leach. We will take the case under advisement. The third and final case on this morning's regular calendar is number 25 CF 45, DeLonte Clemens versus United States.
Morning, Your Honor. May it please the court?
Morning.
Morning.
Got it.
Joel Davidson on behalf of Mr. Clemens. I'd like to reserve 3 minutes for rebuttal as well. This is a case that deals with the District of Columbia's possession of an open container law, which prohibits the drinking or the possession of an open container of alcohol in a public place. And what that is at issue here is whether or not the place where Mr. Clemens was stopped by the police for possession of an open container of alcohol, there was no dispute that he had an open container of alcohol, and was then subsequently searched, leading to a felony conviction, was in fact a public place.
Is
under
that the
statute.
question? I mean, I know that the statute says that drinking of an alcoholic beverage in a public place is prohibited, but then that's not really what the statute prohibits, right? The statute says that you can't have an open container or drink alcohol in a list of enumerated places. It doesn't talk about public spaces. It doesn't talk about really public property versus private property. So
I hate to start off disagreeing, but subsection 4 says is specifically,
any place to which the public is invited.
that is the definition of
Sure.
a public place, essentially.
Right, but then it talks about, I mean, that's not the provision that we're talking about, right? We're
Well-
talking about one, and one is a street, alley, park, sidewalk, or parking area. And it doesn't say whether the street is in a, private gated community, private development, or, a public alley, or whether there's, it's private property with an easement over it. I mean, it doesn't talk about who owns the property at all. It's
Right.
not concerned about that. It seems to be about, drinking within view of others in these enumerated spaces. And maybe you think the spaces, it's incomplete for the concern of, public drinking, but it doesn't say this is about private property, public property.
Well, it doesn't say specifically about ownership of the property, Your Honor.
Right.
I understand that, but what we're talking about is whether or not the goal of preventing drinking in public is consistent with an interpretation of the statute. And I understand that A says sidewalks and streets, but a sidewalk and a street are defined their own ways, but the area, we would argue that the area where Mr. Clemens was stopped was actually a private area. It was paved, no doubt. It had vehicular entry, although that vehicular entry was supposedly limited because it had signs that said private property. At one point, it apparently had a gate that would raise and lower and only allow one car at a time. That seems to have not been in operation at this point. It was not a thoroughfare because, as the police officer noted, the other exit from the property was closed. And I think what we'd be asking the court to do is to take a common sense definition of what we're dealing with here and what the purpose of the statute is. Because if you define sidewalk to mean any paved walkway, then that can mean all sorts of things. And it would lead to some consequences and some situations that we don't think make sense.
You define sidewalk.
I would define sidewalk as a paved area for pedestrian traffic alongside a street. That's the most basic definition, and that
You
is one
define
that is
street.
employed. Yes. A street, on the other hand, is a thoroughfare. What we have here is essentially a parking lot with an entrance. There is no thoroughfare. This allows the individuals to, and also when we.
I don't know that I agree with that, but assuming it's true, is a sidewalk alongside a parking area not a sidewalk?
Not for the definition of this. If it's a privately owned parking area, not open to the public, not where the public is invited. And I know that there have been cases in other jurisdictions that have.
What do you say, where is the evidence that it's not open to the public? I mean, it
Evidence
seems
is-
to me that the police and anybody else was able to drive in and drive around that area. And one would think that the homeowners would be glad they were.
Well,
This would be pretty
police
inconvenient
can
to drive.
patrol private property. They can't enter on private property to patrol it, but this is a question of whether the public is invited there, and the signage and the fact that there was at some point that one of those exits has been, one of the entrances to the area has been closed off, that the signage says parking by permit only, says that there's a lift gate or
I mean, you keep saying this is an issue of whether the public was invited. I mean, that's subsection 4, any place to which the public is invited and for which a license to sell beverages has not been issued under this title.
Yeah.
Right, so sure, whether the public has been invited is relevant there. But number 1 just says street, alley, park, sidewalk, or parking area, which seems to indicate, I mean, a street is where, people travel in vehicles.
Right, well,
Right, an alley, again, is off of streets. Sidewalks are next to streets, and parking areas are where vehicles park.
actually, the original,
I understand parking area used to have a different meaning, but I
Yes.
think now it has sort of the more contemporary meaning.
well, but one of the case that the court, Campbell case
Yes.
suggested that meaning does not apply. Community. And I'd like the court to think of this as, I mean, yes, other people are allowed in to do things, but this is not a thoroughfare. It is not clear that anyone can go in whenever they want. That's not what this is for. If you're
I'm sorry,
invited in.
I just want to make sure I understand. You're saying the area in which your client was seen was effectively a parking area, but parking area is one of the enumerated places where you can't be in possession of an open container.
Right,
But
but
you're saying not this, it's a private parking area, not a public parking area?
there's a private parking lot, but the Campbell decision described what they actually meant by parking area, what the original statute meant by parking area, and is not because Mr. Campbell was found in a church parking lot. And this court in Campbell 1 and Campbell 2 suggested that that's not what the original parking area meant. It was actually the space sort of between the street and the sidewalk.
Right.
So what we're dealing with here is a parking lot, I would say, to distinguish it. And a parking lot can be open to the public. It can be. Go to Safeway and go to the parking lot at the mall. It's open to the public. This is not that. This is
Why are you saying it's a parking lot? Because it sure looks like a street to me.
well, it extends through the
And
community.
You looked at it and it's not just a bunch of parking spaces.
Well-
It is,
Because of the way that the private community is laid out, you have to be able to get to a place to park in front of your house. So the parking area, there's
But
an
why does that,
access.
I mean, sure, so maybe the place in front of your house is the parking area, but I'm struggling for the words, the thoroughfare, the lane, the alleyway, the path that one takes to get there through the community looks an awful lot like a street to me. And it just seems really that what you're saying is because it's on private property, but there's nothing in the statute about private property, that it's not a street, it's a parking area.
I would say certainly it's a paved area where you can drive back and forth. But I think we can distinguish that in terms of, because of this is about drinking in public, I think we can distinguish that just like we would distinguish a private driveway from a street. If you pull into a private driveway in front of your house, or you're standing on a private driveway in front of your house, that is a paved piece of land that you can drive on to get to somewhere. But I don't think in this situation that the purpose of the act would apply to that, because you're on your own front yard. This is, I would call it a shared area. It's not private in the sense that everybody has their own little driveway, but it's a shared area, not open to the general public, or not inviting in the general public.
Are you primarily relying upon the purpose of the act as opposed to the plain language?
Well, the purpose is in the title of the act is pretty clear. I think that
Do we know if the legislature drafted the title or whether it was just the,
that I can't tell you, Your
title.
Honor. I do know
Right,
that
oftentimes titles are just attributed to legislation that doesn't actually, it's not the legislature's words.
well,
In which case it really wouldn't have much meaning in interpreting the statute. Right,
Well-
if this just comes from West.
I understand, Your Honor.
May I ask, even if we characterize this roadway as a parking area, I'm not sure I understand where that gets you, since subsection 1 prohibits carrying an open container on a quote parking area.
Again, I would look to what Campbell decided,
Well,
Campbell won,
I
where the
understand
court.
Campbell to say that even though the church parking lot, maybe you couldn't have an open container there, this car was parked in a sort of an anomalous green space that was neither street nor parking lot, parking area, nor sidewalk, nor nor park. It was just this anomalous area, this green patch between two parking lots that the court said, well, the legislature didn't mention these anomalous areas, so we're not gonna, say the statute applies to them. But it would have applied if he had been in the church parking lot, even though that's a private parking lot.
It's unclear, Your Honor, from the language.
I thought it was
of
clear,
Campbell.
all right. Okay.
What I would like to say, Your Honor, is that, and I'm running out of time, but that the idea that by stepping from the grass onto the pavement, you have then violated the law in a privately owned area, we don't think is that makes sense in terms of what the purpose of this statute is.
Are you relying on particular legislative history?
I've looked at the legislative history, Your Honor. It's gone through many iterations. And there's no definitive statement about private property, but the gist of the law deals with public spaces. That's what you're looking at. Every single part of this deals with the public space. And I think we'd ask the court to consider that the language, the first part of the language is that was the original part of this statute, and the other parts were added as time went on. And so the purpose of the law, we believe, is not served and would not apply to a privately owned place, be it a paved walkway or a paved driveway that is not open to the public. that it should only apply to those things that are open to the public, because that is the purpose of the law. And that is what, if you read all of the sections of the law, it's about preventing public drunkenness. It's about preventing incidents that arise when there are people drinking in a public place. And what we have here is if the court construes this in the way that I think maybe you're suggesting, you'd have a situation where you live in a community like this. There's a playground on one side, but to walk across, to get to the playground, you have to cross the street. And by carrying your alcohol, which you can drink as you like in the playground, you have violated the law by crossing the street or stepping on the sidewalk. And,
what's the distinction between your concession that a private parking lot like Safeway or something is open to the public, but the one here isn't, given the facts that what we know of it is the gates open, people come and go.
Right. Well,
What's the difference?
well, I mean, because people are invited in to the Safeway. I mean, the case law generally, not surprisingly, most of the case law from other jurisdictions deals with parking lots near liquor stores or bars. And the idea is that people are invited in. They want people to come in there. Here, there's no information or no suggestion that people other than the ones who live there are invited in. In fact, the sign says private property. You can't park here without a permit. There's supposed to be a gate that maybe you would need something to activate the gate to get in, so on and so forth. So there's information there, and there's fencing by the side of the gate, which you don't find in a normal parking lot. So the church one was a good question, because the Campbell Court didn't really deal with whether or not that was open to the public. They didn't address that or not. But they didn't give they didn't say, well, if he had been on the asphalt part of this parking lot, we would have said, yes, it's polka. But since he was in the median, a grassy median strip between two parts of the parking lot, they said it was not a polka violation. So I see my time is up, but we would ask the court to reverse the findings of the trial court and reverse this conviction. Thank you.
Thank you. We'll give you a few minutes on rebuttal.
All right, thank you.
May it please the court, Mary Fleming on behalf of the United States. The trial court did not err in denying the motion to suppress. The statute does not distinguish between publicly and privately owned property. And even assuming the statute limits subsection A1 to areas that were open to the public, it was reasonable, objectively reasonable for the officers in this case to think that the area was open to the public, such that they had probable cause to believe that the POCA statute was violated.
You think that a high-end argument is properly before us when it was not raised in the trial court?
I think this court can consider it. We agree it wasn't raised below, but it's a purely legal question.
I don't think that's necessarily true. It's partly a factual question. What the officers were thinking, what their reasons were for thinking it, and so on.
Hines says that what the officers were thinking is irrelevant, that it's a purely objective inquiry, and that is not something that the court considers. We do not examine the subjective understanding of the officer at all. So under Hines' understanding of it, we would submit that it is purely a legal question. So if there is a question about whether the statute applies to privately versus publicly owned property, we think this court could consider Hines. Whether the property was open to the public is a factual question that, even if this court disagrees or would have come out differently, is baked into the probable cause inquiry. The officer doesn't necessarily have to be correct, but certainly on these facts and a reasonable objective, an officer could have thought that this was an area that was publicly accessible. So even under that interpretation of the statute, there was probable cause to arrest.
Can I ask if there were, this were a more serious gated community where there's a hut and a gate and it's manned and people coming into the apartment complex have to show their ID or say who they're visiting and they'll call up and get permission to get in there. Would you see this differently?
Under our reading of the statute, which is that there is no public accessibility limitation into the word street sidewalk. It's not in the statute. We don't think the ordinary understanding of those terms requires that either. Then no, it wouldn't change our understanding. If we're in the world where we're going to accept for sake of argument or for sake of the probable cause inquiry, that there is a public accessibility requirement, I think the answer would come out differently there. But we're just assuming, even for the sake of argument, if it has to be open to the public, there was still probable cause.
So if I'm thinking of like the the places in the city where there are a lot of places where there are row houses and front iron fences that are low and gates to go into people's front yards, and then sidewalks that go from the gate to the home. Basically, are people allowed to have a glass of wine out on that sidewalk in the front of their house?
You would say no, and I would point to the amendment to the statute, which which specifically carves out parking structures that are integral to the to row houses, but that project onto the parking, such as they're projecting on a public property. The council understood that the statute to cover that, and they specifically carved out an exception to allow folks who are on their front porches, because that's integral to the structure, or even in a bay window, which sounds a little absurd, but that was an issue. So under that reading and the fact that the council had to amend the statute to carve that out, if we think that the path leading to the front of a house is a sidewalk, then POCA would apply there.
Is the front yard a park, or
That's
like as long as someone like jumps from their house to the grass without touching the sidewalk, or is that a park?
I think that's a tougher question. Whether that's a park or not. If it is a park, we think POCA applies even if it's inside the gate. But I think parks, I haven't looked at the definition of them, but it may have some aspect of communal enjoyment involved. And if that's the case, maybe a front yard's not a park. But
This creates sort of this strange patchwork of, I can sit on my front stoop and drink my glass of wine, or I can stand in my flower bed right next to the public sidewalk and drink my glass of wine. But if I'm on the walkway to my house, I can't drink my glass of wine.
that may be true, but it's also conversely true that
That's
there.
not, it's not that I have to have my glass of wine right now, but I'm just saying, hypothetically.
There also could be a patchwork conversely, where in the district there are areas that are private and maybe the public can access them, maybe they can't. But you can have your even under appellant's reading of the statute, you can't have the glass of wine on this part of the sidewalk, but you can have it on this side of the sidewalk, even though there's not much difference between the two. I think the council chose street, sidewalk, park, alley. These are pretty broad terms that are meant to cover places that are outside. And we think that should be read literally with the ordinary understanding of those terms. And again, this is a probable cause inquiry, so there certainly was probable cause to believe that the POCA statute was being violated.
What is your view of the legislative history on this? And are you, I think you cite the Alvarez case where Judge Schwelb writes the decision about whether I think sidewalks weren't in the statute at the time, and then maybe the statute was amended to add sidewalks, but this was one of the pipeline cases or something. And he goes on about how the legislative history of the open container statute reveals that it was designed to apply to all public areas, and kind of mentions a couple of committee reports that do seem to focus on drinking in public being the issue. Is your view just that, well, this is drinking in public, even though it's a private complex?
Yeah,
Yeah.
yes, and we think that again, using these broad terms that are outside and generally areas that are visible to the public or where other people are is a reasonable way of effectuating the legislative intent of prohibiting drinking in public. I will note, if you go all the way back even to 1934 or so, when prohibition was ending and this Congress originally enacted this statute, it was always preventing places that the public is invited and any street, alley, sidewalk, park, or sidewalk wasn't originally included. But that was always a separate exception, which suggests that it's broad. It's even broader than areas where public can access it. That are publicly accessible. So I did go through the legislative history pretty extensively. There's not a whole lot one way or the other. If I had found something, I would have decided in our brief. But we do think that this broad prohibition on drinking streets, sidewalks, alleys, et cetera, is a reasonable way of effectuating the legislative intent of prohibiting the public nuisance that comes from drinking alcohol.
What to go back to Judge Beckwith's hypothetical, what if this were, a private community, where everyone owned their own land and then, contributed to the upkeep of the streets and they were a big wine drinking community. That's sort of the nature of the community, is that everybody liked to drink wine outside with their neighbors standing in the street and socializing. Do you think that the government could shut them down?
Yes, if they're on it, if they're on
It
a
was
side.
part of the homeowners agreement, and this was part of the bargain of what people bought into when they bought into this community, that they wanted to have social events and public drinking.
Yes, we think POCA statute would apply if they're on a street or a sidewalk, even if the residents of that community aren't particularly bothered by public drinking. But again, backing up, that regardless of exactly how we interpret the statute, the officer's interpretation was objectively reasonable. We think the court can simply affirm on that ground. If there are no further questions, we ask the court to affirm.
Thank you very much. Mr. Davidson, we'll give you 3 minutes.
Yeah. Couple things. I think that following the Hine argument would be procedurally unfair to the defendant here, or appellant here, I should say. This was not raised before the court. Government counsel had opportunity to question the officer about what they thought, what they knew, what their training was, and so forth. And the defense counsel never had a chance to really to make a record about that. So we would ask the court not to entertain.
What about your opponent's point that it's a purely legal question, and Hine even says that?
I disagree with that. I think that's not a purely legal question because we don't know what, in light of the Campbell decision, what training has been given to officers about where the law applies, and we don't have any information about what procedures were in place to determine whether or not a particular area was or was not included in the statutes. I think had they made that argument, it's something that could have been fleshed out in terms of factual information. It's not, I don't think it's purely a legal argument. The other thing is just, there's no, with the examples the court brought up, I think are important because what we're asking the court to differentiate between shared area and a public area for purposes of the statute. The statute is about public drinking. And in a shared privately owned area with the agreement of the individuals there, that this statute is not designed to apply to that. It may be because the statute is so much older and the original language still pertains, but we would argue that a shared area with privately owned where the individuals not open to the public, where the public's not invited, should not fall under the gambit of this statute. Thank you.
Thank you very much. Thanks to both of you for your briefing and your arguments today. The case will be submitted and we're adjourned.
All rise.